3 సార్లు, 4 సార్లు.
మరి అప్పుడు వచ్చినప్పుడు ఏం అడగట్లేదా?
అడిగినా తీసేయట్లేదంట.
ముందు వాతావరణం మంచిగా దొరుకుతుంది. మేడం Reliance.
Yes. Advertisement means there is number 2, item 821.
Item 12 is electricity.
Item 12,
Serenas.
when the matter is taken up for hearing, Srimati Sunita. What is the good name? Your name?
C. Sunita.
C. Sunita, Land Council representing Sri A. Surya Narayana. Fairly submits the cause in the request reports. Accordingly, the requisition is considered in yes. Yes.
Number 3, item 22 to 38.
Item number 24, man.
24.
It has become infractions.
Yes.
Item number
Item
30.
24. What is your good name?
K. Sai Pawan. Sai Pawan.
K. Sai Pawan, Land Council representing Sri M.V. Subbareddy. Yes.
Item 32.
Lord, item 25.
Item 25. Yes. Land Senior.
Lord, the other market matters are coming on 20th. Lord, I would physically appear and do all these cases. Lord, should have it on 20th.
28. 20.
20,
Yes.
yes.
Yes. Item 25. At request of the Land Senior Council. Post on 20. Yes.
Item 32. Kindly next week. Petitioner council request.
Item 32. Recovery of amount. Anything survives? How? Why? Yes. Item 32. At request. Post on which day?
Next week.
Next week. 20. Yes. 20. Yes.
Page number 4, item 39 to 52.
Item 50, petitioner from 52 Milad, 52 and 53. Bhanu Prakash requested to reply counter for 2 weeks.
Why reply? 2012 matter, you are seeking for filing reply in 2023 after 13 years.
Finance and count.
Banu Prakash busy with elections. Item 52 and 53, at request of the council for the petitioner, post on 24th. Yes.
Page number by item 54, 65.
So item number 58.
Hmm.
Requesting 2 weeks time. and
Already assigned at your request, last occasion.
General misplacement.
Collect from the port, we already given necessary
Next
instruction
week.
to the posting
Next
clerk.
week.
Wherever the files are required, please collect from
Next
the,
week.
anything survived
I
by
don't
nursing law. This is for non-implementation of the NPM order granted by this court on 29/2016.
What is the matter? I don't know. Misplacement. Next week at least.
58. Get request, post on next week.
Much.
Yes, 17.
Page 6, item 78. Page 7, item 79 to 92.
81. It's item 82, get request. Post on, nothing, post on 23, yes. 23/11, yes.
Page number 8, item 93 to 108.
My lordship, item 98, my lord. Mr. V.S. Sudhakar requested next week. He is for the petitioner. He has to get certain documents from the Sangha.
Request, post on 23/11, yes. Okay.
Page number 9, item 108.
Yes, Ravindra Reddy, yes. Not paid. No, due to the election. Yes. Not till. Now the weather revenue. Now with the. Yes. Now counter fine, unofficial response. Yes, post on 2011. Yes. Hare Krishna. Yes. 1 minute, 1 minute. Your place. Right to Bima. What is the stand taken by the official respondents by the yes, oops, sorry, 28/11, yes. Pursue before the registry, why second slip? Yes. What is the urgency? Which year matter? Who is making illegal construction? Yes. Post on 28/11, yes. 28/11, yes. 28/11, yes. Yes. Now this week 3 holidays. Just next week. It will reach. Wait. Which year matter? 22. Counter file. Counter file. Yes, that's why. You furnish the court slip also to the other side. Better unofficial respondent. Yes. Yes, better. They will file meantime. Yes.
Your lordship, kind permission. IA is pending without consideration. The membership in the cooperative societies, without considering my candidature, they are allotting
Why
part.
your office not representing several matters?
Milord, in Genco matters, Milord.
Not Genco, private matters.
I'm sorry, Milord. I'm just sorry.
Especially one association, cooperative society.
No, I'm sorry for
Last 3 weeks, no representation. We will see
that.
next
Notice,
week.
Milord. Next week.
You make a request next week. No.
Because there is an urgency, Milord.
28/11.
Yes.
So with your kind permission, my lord, see to move a lunch motion, my lord.
What is the urgency? Now, yes, Surya Satish matter, all Surya Satish matter wants after election, why you are moving like?
If your lordship, because yesterday this matter has come up for admission, wherein the respondents were trying to lay a road in the agricultural land.
It's already urgent.
It was adjourned for today, my lords, but it has not come up on list, my lords.
No pending
lord.
matters, no lunch motion.
My
Very
lord.
post on 14th is.
My lords, there is a threat of disposition, my lords. There is standing crop.
That's the laying of road in the LRA debate mandal. That is ne? Yes.
Yes, my lord.
Yes. Standing
There is a
crop is
threat
there.
for disposition, my lords. My lord,
Monday.
let that be recorded, my lords.
How can they? There is no court file. No question of granting lunch motion in pending writ petition not proper. Take up the matter on Tuesday. Yes.
There is a threat of disposition, my lord. Kindly consider the matter, my lord.
Yes.
I'm
Tuesday. Yes. Please go. Standing counsel. Meantime, please. There is a paddy standing crop. Photographs are there. Yes. Some. Yes.
Journalist item number 150.
Yes, madam.
Release of vehicle.
Matter pertains to release of vehicle. What is the quantity of PDS rice? Whether
Not
vehicle
a-
is
it is
first
assumed-
offense, second offense, or third offense. How many times you were vehicle involved in with the
Right,
same
the
offense?
different vehicles is a different person.
Vehicle is one, driver is different.
No. Different, totally different vehicles.
Your vehicle,
Is owner
how
also.
many times your vehicle involved in the particular offense?
It is assumption, just the
You have to
higher the
not appear.
petitioners. 29 tons of the lorry,
Yes. Yes.
50,000.
Now this is a matter you want pending. You want to file counter or you
Close the-
Dispose it.
Dispose it.
Right, because the interim order is nothing but.
Nothing but that is the only why you are in all the matters we are seeking is time for instructions.
No, it's only,
We
it was
are
a
seeking time for instructions in the case of.
Yes, right. Yes, ma'am. Right. W.
lorry is the disposal.
3127.
CC2.
Now the vehicle who has to release?
Police officer. Both the respondents. Not
The vehicle is in the custody of both respondent, but the releasing authority is the collector, collector respondent.
Respondent, but 224 are there.
both the respondents.
224, yes. Yes. Tomorrow holiday,
Means
Monday holiday,
Us
Sunday
today.
holiday. CC today is not possible.
evening.
So say Monday, 14th or 15th, yes. CC 3 days, yes, better.
Pending 6 year procedure.
Yes, pending 6 year proceedings. Two requests.
Yes, and you ready? Okay.
Yes, Sanjeev,
Mate,
what is the issue?
issue without notice, they have. Committee.
Even.
Grievance people, lordship. The third respondent issued the notice on 25/10/2023.
20,
25/10/2023, lordship.
the respondent, yes,
Meeting was held on 29/10/2023.
yes.
As per bylaws, there is 10 days time minimum.
Now, what happened, now the meeting scheduled to be held on, which date? 29/10/2023. What happened on 29/10/2023? You're not mentioned anywhere.
Ad hoc committee was appointed, but there are no proceedings. They have not communicated any proceedings.
Now now everything, now this repetition is infectious. Court officer, is good. Now you have not stated anything. The general body meeting held on, scheduled to be held on 29/10/2023. Pursuant to the impugned proceeding dated 25/10/2023. Issued by the district cooperative officer. What happened on 29? So now the meeting held on 29/10/2023. And the members of the society attended meeting, general body meeting, passed a unanimous resolution electing the 5 ad hoc committee members.
The notice itself illegal, Lordship.
Now unless and until you challenge the consequential proceedings. Now please.
As per the 29 of the Max Act, they have to furnish the report.
You are correct. Yes. Notice before admission.
He was appointed some other officer.
Yes.
He was,
The team Venkatreddy also, Deputy Registrar of Cooperative Society.
at that time, there is no quorum. He was urgent to.
Yes, clandestine government period. T23. Yes.
Lordship, IA may be ordered
What IA?
for furnishing the documents pertaining to the inquiry report.
Then what they were, whether it is along with the counter affidavit, they have to enclose all the documents. Now, why the separate IA is required?
I have
Now,
filed the
the bounded
RTA application also, Lordship. They have rejected.
rejected. Then, as per the provisions of RTA Act, there is a remedy of appeal provided.
Even though appeal,
Penal provision also there.
violating the principles of natural justice.
Now, if they are going, unless and until, along with counter, they have to enclose the documents. You see?
Yes. Okay.
Yes, madam. 12. By that time, you have to file counter. Yes. Yes.
Action for illegal construction of the
Who is making illegal construction?
respondent of 6 million. I made a
Response. In your property?
Even though you did, I stated that.
No. The unofficial respondent making construction in which property?
Property, I stated in my property, but my grievance is going to exist of illegal construction without any permissions.
No, what is your grievance?
My grievance is that we have the certificate, we have the.
No. When the unofficial respondent making illegal construction, by virtue of construction, your rights are affecting.
But that you are not the.
Or in interest of the village, you are filing the writ petition. Whether your property rights are affecting or by virtue of construction,
That my grievance only limited to the petition. They are making illegal. The authorities have to take action whenever the illegal.
who are you? What is your locus?
After my final certificate, my father is the owner of the property.
You are saying that in your property they are making.
This is my affidavit. Because that regarding the unofficial respondent, I take up my.
Is what you say. If the unofficial respondent having any valid permission or not? Are you initiated any proceedings as per the provisions of 2018 Act? Why the Gram Panchayat? Where is it? Notice is already issued. Yes, notice before admission, land accident government period panchayat or land government period panchayat. Now the construction, second slab, second floor,
I made a representation.
already it's now is
Yes. I'm a permit for personal notice.
already permitted.
Mobilize.
That is my lord. Threat of demolition, my lord.
Yes.
Without prior notice, my lord.
Who is trying to demolish?
My lord,
four, my lords. And only fourth is interfering in my
Where is your permission?
page number 12, my lords.
Page number 12. Permission granted when?
In 2019, my lords.
As per the conditions, with how much time required for completion of the construction?
My lord, the construction is going on, my lord.
Now, as per your own sanction approved plan, what is the time period mentioned? Construction to be completed. Now you are obtained the permission in 2019. You have started construction 2023, whether permissible. Now the permission granted by the Grama Panchayat already expired. Please see clause number 4.
Yes, my lord.
నిర్ణీత ప్లాను మరియు స్థలం యొక్క పూర్వములు నిర్మాణము 24 మాసంలో పూర్తి చేయవలెను.
Yes, my lord, but my lord, we have started the construction.
Where is the photograph? Now, basing on the permission granted by the Grama Panchayat in the year 2019, whether you are entitled to make construction in 2023.
Not in 2022, already the construction is done, my lord. Only the, my lord,
Yes, what do you say, standing council? Now, record. What would you want?
my lord, let that be in the, my lord, because as per my instruction, there are.
Now, which respondent is interpreting Grama Panchayat? That is your allegation.
Yes.
Yes, we'll record WP number.
Maybe recording.
Yes, WP number 31.
Same, let's say.
Yes, remaining 6 and 7 also. 6. Yeah.
Obliged.
Yes. Yes. What here I what is your good name? Balu initial. D. Balu, Learned Council, representing Sri R. Chandrasekhar Reddy, Learned Standing Council, appearing on behalf of the respond number 4 Grama Panchayat. Yes.
Obliged.
Yes. Yes.
For appearance, number 8. Hence, whether it is utility.
I think you should wait till I complete the. That contempt is filed for violation of the interim order made in WP number 20666 of 2022. When the contempt came up, my lord, counters are filed, replies are filed. Ultimately, on 13/10/2023, if your lordship kindly takes the order in the contempt, my lord, 13/10/2023, the court has prima facie found that there has been violation of the order and that there is contempt. But however, on the request of Chandrasekhar Reddy appearing for the respondent, that they have filed a vacate petition, the petition, and the vacate petition also will be taken up. Therefore, the court directed, my lord, that the registry will list this matter along with the vacate petition after obtaining instruction from the Chief Justice. Now the vacate petition and the contempt have come up. If they are willing to argue the vacate petition and further, my lord, this court also held that because the next date of hearing is uncertain as to when the instructions of CJI will be given, dispense with the appearance was, my lord, given only for the present. And next further hearings, my lord, they will be present in the court. If they are willing to argue the vacate petition, I will proceed with the matter.
I know only 3 weeks and
No, 3 weeks. No, this is not in a general case. This is in a specific case. There is a judicial order passed by the other nulled judge. Now, the pursuant to the orders passed by the Honorable Chief Justice on administrative side, the matters are listed before this court.
Then your lordship will make the interim order absolute. First, after 2 years, I have no objection. We'll take up the contempt case. If they have no case to be argued not for vacate, having filed vacate, they cannot seek time.
lastly,
Make alternative arrangements. That's not a ground seeking 3 weeks like, isn't it? Especially the person appearing on behalf of the particular institution in a standing counsel, not in a private counsel. No, that is not a ground. You are seeking, that's not a ground. Or the party will appear and he will argue the case. No, this is a contempt case against in person.
sir, I'm here. Presently, you put this on.
It is not a clarity given to a done to the court.
1 minute, madam. Please, this is a contempt proceedings. Now, the judge specifically recorded some reasons. Now, the vacate stay, due to the pendence of the vacate stay petition, contempt case and vacate stay petition clubbed together. Now, vacate stay petition, whether you have to argue the vacate stay petition. If you are not having,
Or maybe final, my lord.
no,
We'll come and we'll argue the matter.
when?
At least 2 weeks.
No 2 weeks. Next week, choose any date, 14th to 17th. Get instructions, which date convenient. 14th to 17th. Between which date convenient. 14 to 17. 14, 15, except 15. 15th final hearing day. 14, 16, 17. Get instructions from your trainer, just short pass over. Specifically, the specific case, that's in a specifically posted. Now, yes, short pass. You get instruction and which date convenient? Before lunch or after lunch? I find. Yes. Yes.
In this matter, we have to file counter.
No, Padmin mentioned counter not
Because your lordships, they are seeking, after pronouncement, your lordships, they are when seeking for correction, your lordship.
correction. Now, this is the party
Instead of
passing
filing-
person is not aware the procedural aspect. Instead of filing amendment petition for seeking amendment of the prayer, we file only memo. The ministry also committed a mistake accepting the memo.
My
That
only
is a mistake.
objection is
Now, the person who is appearing as a part in person to just to only now is in a restricting the first limb of the
we
prayer.
have to inform the
Because of
consent, your
the
lordship, that
particular
is.
relief was not amended through process. That's why the court also, that's why.
Lordship will make, we are seeking only some time, your lordship, because we have to inform the concerned officers, because we have informed.
Papers were served when? Petition papers were served when?
I thought on the 4th, my lord.
4/11/2023.
Lordship may accommodate some time, your lordship. So,
We not informed at least to the yesterday. Now he has been
It's,
traveling from 110 kilometers or 100 kilometers from Kamareddy to Hyderabad.
my apology, lordship, for
Not apologies to the court, to the
to him also, your
last week there's no representation in spite of the court sent message, special message.
only 1 week, your lordship may accommodate.
It's not
Not
good for-
not
it's
my,
not a good for institution. That is not only your. Now we are to see the interest of the institution.
not on Fridays, your lordship.
16th or 17th.
Not on Fridays, 16th, your lordship.
16th. We'll give one opportunity.
My lord, my humble submission here. You see, while I served
Yes,
them on the 4th,
Learn system bone period.
1 minute, just if you
Just
can.
not only 1 minute. We will, if you want, this court is going to hear 1 hour also.
In fact, just I wanted to know from the government side, what do they want to inquire?
This what then
So that I can get prepared. My lord, you see here what happened. It is there.
because of your side also some mistake. You filed in a memo for amendment of the prayer that is not permissible. The reached is simply accepted. You have to file in a necessary application or 6 Rule 17 seeking amendment of the prayer. Now that is a, if this application is filed, if the application is ordered, that prayer has to be modified. Now this court proceeded basing on the pleadings in the OA, basing on the counter affidavit reply document. Now this is a case where club put together. You have filed memo, several memos. That is not permissible. Yes.
Meanwhile, my lord, meanwhile, see, 2014.
Now you are waited since 2017. This court allowed one OA or writ petition, one writ petition dismissed. Now you want some clarification. Just to their response also required to avoid further technical. To render substantial justice to the parties, this court is adjourn the matter to 16/11/2023 finally. Get ready.
Bless you.
Yes, on that day. No, yes. Yes,
My lord, is it in the morning or it will get posted at 2:30?
Mr. Which
2:30, your lordship.
2:30?
Yes, yes.
2:30. And specifically we are not posting any cases 2:30. This is an understanding between both parties 2:30.
Yes, yes.
You come on 2:30. Yes.
And my humble submission with regard to 1451, my lord, already IA was filed, IA is still pending, and the prayer was.
That is an only date. This
Only modification on the 17th.
This court will take care of that. Even in the absence of modification, this court passes in a mandatory direction to pay the particular pensionary benefits from the date of appointment to date of retirement. That is your grievance was resolved. Even that correction is also not required. Even if required, this court is going to take care. Yes, next case.
Yes.
But with regard to this 1450, the division bench has already ordered.
Yes.
They had not brought before the under.
Yes, yes.
This was already attended to and I filed.
This court will take care. Yes, 16th to 30. Yes, madam.
Yes.
On that day, no,
Yes.
not to give any inconvenience to the.
But that will be made finally, my lord.
Yes, finally. Already stated finally. Yes. Item 8 and 8 and 9.
Sorry, I apologize, but kindly make it
Already stated Haragopal Garu, how many times you are?
No, I say because
16th, 11/20/23 to 30. Yes.
finally.
Yes.
17.
17. Yes. Anyone representing Sridhar Reddy or Butch Reddy? Butch Reddy. Just inform to them item 8 and 9 at the request of the Learned Standing Council. Post on 17. Get ready with all. Yes.
Item 11.
But this matter came up yesterday, my lord, posted today for our inspection. My lord, lordship migrant short parts are my lord, we are yet to get explicit.
To say reasons why, whether the petitioner is not entitled for rice bandhu, reject.
Your lordship, I am for R section this.
This right bandhu is concerned, my lord. The revenue people that only concerned to the black or unblocking the truth.
Okay. Only this court directed the respond number 1. Who is the respond number 1? Tahsildar, Madepalli, Tahsil Office, Madepalli, Mandal, Rangari district. Dispose of the objection of the complaint stated to have been made by the petitioner on 30/8/2019 in accordance with law within a period of 4 weeks. This court wants, pursuant to this order, what steps the respondent number 1 considered and passed any order. That is only limited purpose. Whether the petitioner is entitled or unofficial respondent entitled, this court is not having any such power to decide their title dispute or any other dispute.
My submission, your lordship. After getting the order, my lord, either petitioner or respondent, my lord, uploading the order copy to block the survey numbers, my lord, unless but any online, my lord.
Why you are not in passed the particular 2 lines order? Yes, pursuant to the circular, pursuant to the procedure, this is required. The petitioner is not submitted this in a requisite document, is not eligible to consider the claim. The complaint is rejected. Now sitting,
Well, only considering application also made no physical, only online, but that is a problem. Your lordship. But
are you file counter?
not in that sense.
Now, two, this is this is a clear violation of the arts of the sport. Neither the respondent not filed counter explaining the reasons. This representation cannot be taken into consideration for this reason, or not passed any order, keeping silence from 9/12/2019. Not a ground for adjourn the case.
I can come with induction on Tuesday.
On payment of cost yesterday also.
But
This is not the way.
but the subject is Raitu Band is concerned that this respondent, the Tahsildar is concerned only to
Why the Tahsildar not informed the same
true that is
Tahsildar, RDO, collector, principal secretary. What is land assistant government period appearing on behalf of the official respondents. Period appearing on behalf of the official respondent. You have to say reasons why the entry order granted by this court is not compliant. Otherwise, this court is going to initiate this motu contempt against the Tahsildar.
So next what?
Land assistant government period revenue appearing on behalf of the respondent is 124. Seek 3 weeks time for filing counter. Similarly, the learned council appearing. You are appearing on behalf of the
R6.
5 Nursing Rao.
No, he died.
Died.
I am not on record.
No, died అయిన తర్వాత రికార్డ్ లోకి ఎలా వస్తారు?
No, I filed only wakalat for R6.
Land council appearing on behalf of the unofficial. No, he is represented, but that's in a judicial order.
True.
Or the officer has to give respect to the judicial officers. If any difficulty arises, they have to file a vacancy petition explaining the reasons. Keeping silent. Yes.
Okay.
Yes. Yes, anyone representing Bhanu Prasad? Yes. When the matter is taken up for hearing on 8/11. Yes. Why you are keeping silent? Yes.
No, Malad, there is a small technical glitch, Malad.
Yes, yes.
In this matter, I seek time to next week. Whether
No
cause
time.
survives
Next
or
matter
not,
listed under the caption for
cause survives
dismissal.
or not, I have to inquire.
Cause, now this in a cause does not survive according to the court also. You are seeking renewal of the license. Hybrid bendy is no more in existing by virtue of the amendment of the controlling orders. You want dismissal order or you want to argue? No, the matter listed under the caption for dismissal not in. Now 8/11/2023 no reply.
Malad, day before yesterday it was listed, Malad. We couldn't represent my apologies, Malad. Malad already addressed the email to the company. My lord,
Yes.
whether the call survives or not, we have to reply, my lord. The lordship may take it up on Tuesday.
Yes. London Council K. Sai, Sri Sai Krishna. What?
Harsha.
Harsha.
Sai Sri Harsha.
Sai Sri Harsha, London Council representing KV Banu Prasad. Seek short adjournment for getting instructions from the petitioner and to proceed with the matter. Sorry, for getting instruction and to proceed with the matter. It is request. Post on 14/11/2023. Yes. No further adjournment will be granted. Yes. 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 Anything survives?
I think the earlier directions were issued by the Honorable Court.
What is the issue? Respondent in proceeding illegal contrary to the direction. There is respondent initiated and acquisition proceedings. Biknur Mandal.
Is contrary to the directions of.
Now we are appearing on behalf of the petitioner as well as the respondents. This is your own department.
No, no. Market committee is not.
This is not marketing committee. For the purpose of what purpose the land?
But the council Milord is out of station.
No, this may very the matter already list came up for hearing on two occasions, no representation.
Even his name also he cannot appear, Milord.
No, you have to make an alternative arrangement. That is how can this court is not?
He get 1 week time, Milord. If the matter survives, we will make alternate arrangement and proceed with the matter.
See, Hari, please, London Council.
Sorry, Milan, last.
Yes. Only this, for secure your presence, only this matter listed under the caption for dismissal. Yes. Yes, yes.
Sorry, Milan.
No, why sorry? Yes, you are. What is the issue? Not allotting house number.
This matter listed after 15 years, getting such whether task service or not, Milan.
Nothing survives. Not allotting the house number. If the Gram Panchayat is not allotted the house number for your benefit, because the petitioner is question of payment of the property tax or house tax does not arise. You are having two benefits. The Gram Panchayat, if the allotted the house number, you have to pay house tax.
But with areas they will collect after years.
Yes, yes.
Only next week, Milord, I'll get instead. Otherwise, I'll report to this court. Matter. It's already done, Milord, and no grievance in this case.
We will do one thing. Now the Kisara, Godumukunta Grama Panchayat, Kisara Mandal, Rangari district. Consider your representation and will direct the respondents to consider.
Yes, ma'am.
WP number 27487 of 2008. The petition is filed for following relief. Heard Sri C.S. Srinivas, London Council for the petitioner, and London P. Kishore Rao, London Standing Council appearing on behalf of the respondent Grama Panchayat. London Council for the petitioner submits that petitioner constructed the house, residential house, in plot number 28, admeasuring 260 square yards, covered by survey number 5 by A, 161, 179, situated at Kundanapalli village within the limits of Godumukunta Grama Panchayat. Now this is in a Kisara Mandal, Rangari district, comes from Medchel.
Now it is Medchel Malkazgiri.
Rangari T district, presently Malkazgiri district, Medchel Malkazgiri district. And the respondent Grama Panchayat not allotted the house number and not assessing the property tax. Now, if the petitioner is going to pay property tax, house tax from 2008 onwards,
Well, if it is assessment, from the date of assessment, I have to pay.
date of assessment, date of making of the application.
Well, because it is not assessed to property tax, from the date, prospective date.
The Learned Standing Council submits the petitioner. Now you kindly see your legal notices, no signatures, whether the no receipt. Permit the petitioner to submit a fresh representation. Learned Council for the Learned Standing Council appearing on behalf of the respondent Grama Panchayat submits that the petitioners have not submitted any representation. The notices which are filed along with the petition were not served, not received by the Grama Panchayat, and the petitioner may be directed to submit fresh representation. And on such representation, the respondent Grama Panchayat will consider same and pass appropriate orders in accordance with law. List of having considered the rival submissions made by the respective body and the Learned Council for the petitioner by way of reply submits that the petitioner may be granted liberty to submit in a fresh representation by granting reasonable time. In view of the above said submissions, the petition is disposed, granting liberty to the petitioner to submit fresh representation to the respondent Grama Panchayat. On such representation, the Grama Panchayat is directed to consider the same and pass appropriate orders in accordance with law within a period of 2 months from the date of submission of the representation by the petitioner. Accordingly, the petition is disposed of. Yes. 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 What do you say? Anything survives, Murali Krishna?
My lord, in this matter, my lord, actually, my lord, I think it was not served. But anyhow, my lord, I have to get it because I am not suffering.
No, nothing survey, Murali. Everything is over. Yes.
Yes, my lord. In fact, they are insisting license, my lord, to obtain the market license.
The Haripreet Learned Standing Council received instructions from the respondents.
My lord.
Subsequently, the petitioners already obtained the license.
When, my lord, it is, my lord,
16 to 21.
2016 to 21.
when, my lord,
Subsequently, nothing service.
nothing service.
According to the renewal license also expired in 2021.
Once he obtained the license, my lord, prayer become infected.
Yes, yes.
My lord, nothing service.
The-
Tender my apologies, lord.
nothing.
My lord, not
Yes.
feeling well, that's why I
Yes,
not.
nothing. When the matter is taken up for consideration, Sri Harry Murali Krishna, Learned Council, appearing on behalf of the petitioners, fairly submits that causing the petition does not survive. Please stop in view of the above said submissions. Both the petitions are dismissed.
Also, standing council also, lordship may.
Yes, Learned Council for the petitioner as well as the Learned Standing Council appearing on behalf of the agriculture.
Prayer become infectious, my lord.
If sought in this petition become infectious during the pendency of the petition, the petitioner obtained license. The license, the response granted obtained the renewal license from 28/2016, and same was expired on 28/2016, ending with 31/33/2021, and placed the copy of the said license in view of the same. Itla cheppandi. During the course of hearing, the Learned Standing Council, basing on the instructions furnished by the respondent, produced the license copy of the agriculture market license.
First respondent.
From respondent number 1. License issued in favor of the petitioner from 28/2016 with ended 31/3/2021. In view of the same, the relief sought in these two petitions does not survive. Accordingly, the petitions are dismissed as infectious.
Both
Yes.
matters.
Both
matters.
Yes, both the
In
matters.
this matter also,
Same.
he obtained the license, my lord.
Same. Yes. ఇంకొక సెకండ్ దాంట్లో ది సెకండ్ మ్యాటర్ లైసెన్స్ ఇస్ ఎగ్జిస్టింగ్. ఎస్, ఇది ఒకటి విధంగా చెప్పండి.
Valid till 31/3/20.
Yes, 30. The Learned Standing Council placed the copy of the renewal of license granted in favor of the petitioner. Then same is valid up to 31/3/2024. In view of the same, causing the petition does not survive. Accordingly, the petition is yes. Both the cases.
Sorry, my lord, I'm
Nothing. Just only yes.
And 1819 cases are
Now, yesterday you instructions, what is your instructions? File instruction, what is your instructions?
As per the.
1 minute. Where is that your instructions? Court officer, yes. What is your instruction? Made WP number 16941 of 2000. Yes, release of stocks.
19 also same.
The main repetition dismissal, content case closed. Now you have to say something about this item 20. That is also same. And now this repetition is filed. This is a different matter. Now this is a item 20 case Srinivas, release of stocks. Direct the respondents to release the stocks. This is non-insulin item 20 case Srinivas. Are you release the stock pursuant to the entry model? WP number CC 1 double. He filed one case. You are correct. They filed two interlock the applications, two entry models. రెండు CC లో కలిపి ఒకటి ఆర్డర్ రాసేది. Both content. Yes, you are correct. Yes. Repetition is one repetition, two interlock the application. Yes, yes. Yes. Yes, yes. 20 కూడా close. Yes. CC లో కూడా no representation on behalf of the petitioner. అది కూడా same. Content cases came up for consideration on 2 dates. Matters are listed under the caption for dismissal. Today also no representation. Yes. Yes, anyone representing Ganga Varaprasad, VVS. Yes. When the matter is taken up for hearing on two levels. Yes. Yes. Yes.
Orders I did not do.
Yes, madam. Are you received any instructions?
Yes, yes, Milord.
Yes.
May please. In this matter, Milord, the records are with the district fisheries officer. Milord, no elections are conducted to the society.
Yes.
But on verification of the society, Milord, these and president and other members of the society, all the petitioners were admitted as members of the society.
Yes, yes.
So nothing survives in this
Yes.
petition.
WP number 19303 of 2008. Petitioner filed this petition following relief. Police have heard Sri M. Brahma Reddy and Mrs. M. Vidyavati, Land Council, appearing on behalf of the respond number 4. During the course of hearing, Land Council appearing on behalf of the respond number 4 fairly submits that during the pendence of the petition, the respondent admitted the petitioner as a member in respond number 4 society and the grievance of the petitioner resolved. We stop in view of the same. No further adjudication is required. The petition is dismissed as infectious. Yes.
Bless.
The grievance of the petition resolved and no further adjudication is required. Accordingly, the petition is
Yes. Close.
closed. Infectious badly closed. Yes. Yes, the petition is closed. Yes. Yes, madam. Anything?
I apologize, my lord. Could not get any instructions. I leave it to the court. The council who had referred this matter also, my lord, is now shifted to Andhra, my lord.
The referred
But
the London Council become an honorable justice. Now he's going to say that this.
But your lordship was
Now
right.
the
My
flag
lord,
has
company is not no longer that. I was able to ascertain,
Yes,
my lord. Your lordship was right in saying that the
Yes,
company is
yes. When the matter is taken up for consideration, the London Assistant Government Pleader appearing on behalf of the official respondent submits that the cause in the petition does not survive. We stop. And same was not disputed by the London Council by the petitioner. And it appears the petitioner, sorry, this is in a society.
Society, my lord,
Yes.
correct. The
Got it.
company, my lord,
Company.
employees, this is employees.
Yes. Anyway, I would say the petition is dismissed as infectious. Yes.
Obliged.
Yes. Now we are appearing on behalf of
Milords, I'm representing N. Vinesh Raj Milords in this matter, 23 item number.
అది కూడా చెప్పండి లండ్ కౌన్సిల్ అపీరింగ్ లండ్ అసిస్టెంట్ గవర్నమెంట్ పీరియడ్ అపీరింగ్ ఆన్ బిహాఫ్ ది అఫీషియల్ రెస్పాండెంట్ as well as what is your good name?
Vishwanath Yadav, my lords.
Vishwanath Yadav. Initial?
No initial, my lord, just Yadav.
Yadav. Vishwanath Yadav, Land Council representing Sri N. Vinesh Raj, appearing on behalf of the respond number
4, my lords.
Respond number 4 submits the cause in the petition is does not survive. Same
My lords,
was not.
I have also filed a memo, my lord, stating that I have no instructions from the client.
No, no instruction, not a ground. Yes.
Yes,
Please see the judgment of the Honorable Supreme Court.
my lords.
Yes.
Oblige, my lords.
Right. Yes. File an affidavit, followed expected. Filed affidavit. Affidavit is not available in court file.
Yes, I filed your lordship.
Ah.
Sir, itself I filed.
Yes,
Yes,
sir.
somebody is also there. I will give another affidavit also if your lordship.
That are not available. What do you say basing on the affidavit?
Well, kindly say, if he has one more copy, he can.
చూడండి అఫిడవిట్ కూడా యుఎస్ఆర్ నంబర్ తెప్పించి చూడండి
Yes, sir, 110594.
ఒకసారి యుఎస్ఆర్ నంబర్ నోట్ చేసి ఎస్
This is also signed affidavit, party signed affidavit.
Yes, 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 yes. Right. We are having trust. Yes, what you have stated in your affidavit.
Third paragraph. In that I and my younger brother are having 410 square yards in premises number 1-13 and 1-14, and open space is also situated in house in front of our house with house number 7-99 for an extent of 62 square yards. But this is not at all been there in his entire pleadings, my lord, even in the both the repetitions also. I don't know why, where from this suddenly has come. He said house number stood in the Gram Panchayat in the name of my younger brother Jagan Mohan Reddy. Thus, we have total 480 square yards of area. My lord, I'll just take your lordship to the counter, which is filed in
1 minute, Pradeep. Whether now as per the resolution passed by the Grama Panchayat, the Grama Panchayat says your client required 15 feet road for ingress and egress. Whether basing on the resolution,
I have convinced my client with regard to same. You only have convinced my client, my lord, that the road is existing since in time immemorial, and that road has to be left by him.
yes, yes.
I understand.
Now this court is going. Now this court is not going to declare the land conflict of the petitioner is an owner of the 480 square yards or 280 square yards. Now this court is not going to give
when an affidavit has come up before this honorable court,
only
the sixth respondent, my lord, at least should be fair enough before this court that whatever he has filed it earlier, my lord, he has to stick on to that when this honorable court has convicted. He cannot, my lord, improve, my lord, his version by adding 69.
1 minute, just only. This court is not going to accept the paragraph 3. Now only the dispute to dissolve the dispute between whether the unofficial respondent is willing to
Last para, you last.
1 minute, 1 minute. Whether the unofficial respondent in your petition is willing to left the 15 feet road I suggested by the Grama Panchayat.
My humble servant, there exists a road. He cannot give any consent to me for the extent of 15 feet road. That is not at all the subject here, my lord. There is a road. He has constructed on the road, which is also been surveyed in the presence of the secretary along with the DPO. My lord, to end all this litigation, my lord.
Yes.
My client only suggested. He has filed this affidavit. He says, my lord, whatever he filed affidavit, let him give one map, because he files different permissions in two.
What map required?
Whichever he has filed in that 28230 and other, as per his own affidavit, my lord, let him give the sketch that this much of area he is going to construct. That's all. There ends the matter, my lord, because he wants to. In one writ petition, he says 2 square yards. I am not at all going in. Now, let him give, my lord, as per the village record reports, he is having 62 into 24 square yards of the 62 into 24 feet of the land. Let him give, my lord, the sketch that wherever he wants to go construction, and it's leave the, my lord, 50 feet towards the north.
Now this.
That's all.
So last minute.
1 minute. 1 minute.
Kindly see, my lord,
1 minute. In the new writ petition 28320, already he submitted one plan to the Grama Panchayat.
Yes.
Now that is
to that extent, my lord, we have no appeal.
Now that is the only plan. Now the petitioner submitted an application for grant of approved sanction plan. Along with the application, he submitted the plan. That is the only plan.
Now in this present affidavit.
No. Now this court is going to say that during the pendency of the writ petition.
Yes.
Now this basing on the subsequent developments. Now the Grama Panchayat says something. Now the Grama Panchayat passed their resolution resolving the dispute between the two inter-se parties.
Not at all, my lord, correct. Because the Grama Panchayat cannot, my lord, even as per act.
Yes. Now.
My only, my lord, to end all this research, let him give the similar sketch.
Similar sketch. No. Now he already. Now the petitioner filed in another writ petition 28320. Just only accordingly. Suppose this court is required any further, this court is going to grant. Now the petitioner filed a writ petition. to approve the, rejecting the permission application on 14/9/2022 for construction of the building plan is illegal. That is not required. Now, the only consequential relief, directing the respondent to approve the building construction permission. This is in a building permission application, page 19. You are having page 18 and page 19. Page 18 and 19. Now, if the Grama Panchayat is going to grant necessary sanction approved plan, basing on this, you are having any objection?
But basing on this, I'm not having any. Letting alert.
You have to confine the same in your affidavit.
That is what now.
No, this affidavit already filed.
Malad, now he's filing.
Now, why this this court only?
Just clarify, Malad, one because
Ultimately, Milord, I stated in last para only.
I'm agreeing with this.
Right, the para only.
Now,
I'm not disputing this plan. I'm agreeing with this plan.
Just you have to put something at the end. You have to add in this affidavit.
Malad, my only.
Just only. You have to now
This-
you are
let him attached this plan to that affidavit and file.
Yes. Now the
-13 and
already
1/14.
filed a petition seeking permission from the respective Grama Panchayat grant of approved sanction plan. This is the basing on the plan. The petitioner want to make a construction.
That's it.
You have to mention
The entire dispute, Malad, I can close it out.
Yes.
Letting
One submission.
Now that is now
What he says that I am improving. He has not stated in the petition that I am using the road and it is existing there and what are these?
Now this matter is reached to some extent.
Yes.
Now this only you avoid the further.
only letting Malad attach that maps along with the affidavit and close.
So already I have filed the map in the petition. Miladi is
Whatever he said in para 3.
Now
I'm saying
just
that
only
there will not be any.
just only you have to add. Now during the pendence of the two writ petitions, rejection, you file a separate independent writ petition. On so and so date, I have already made an application for seeking permission. Now the petitioner wants to make a construction basing on that plan.
And attached that plan along with this one.
As per the plan submitted in the writ petition so and so, leaving the
Yes,
15 feet
yes,
road.
yes, that is it. That is it.
Leaving the 15 feet
Yes,
road.
15 road.
Letting Malad attach that map also to the affidavit.
Map-
Will be closed.
Map
Already on record.
I am saying, Malad, is that now the map is not attached to this writ petition. That is what I am saying.
Already there.
One minute. Map attached to the writ petition 28320. Now we are already now this court already implemented your client as a party respondent. Now everything is in a bond note.
Malad.
As per the Supreme Court judgment, it cannot be included.
One minute.
To avoid the future litigation.
Yes.
Let him, Malad, one paper he can attach, Malad, to the affidavit and file the same before this court.
Same plan which I
Yes.
applied in the
Yeah,
affidavit
yeah,
to
yeah,
go, I
yes,
will add.
yes,
So
yes.
and one word is
Yes.
I will leave the 15 feet road to for the interest and
Petitioner want to make a construction basing on the application submitted to the Grama Panchayat on 23/2/2022.
yes, so lots of and leaving the 15
Yes,
feet
yes.
road also.
15th we'll take up one. Sorry, 16th. 16th. Wednesday exclusive file hearing day. Monday, suppose you have to file the
Some personal inconvenience, I go to some
17th.
other court, your lordship.
17th.
17th.
17th, yes. Post on the request. No, nothing.
Lord, Lord, I have to go. Otherwise,
Nothing.
Yes, yes.
Only affidavit saying that.
Yes.
One
Yeah,
dash-
he understood. Yes.
one
Why-
dash
why-
13 and 1/14. Letting
Yeah,
both the-
113 is not it as a, nothing is not a party unnecessarily why it should be done into.
Please, at request of both the councils, post on 17th. Yes, under the same caption. Yes.
By enclosing the.
Milord, I mean,
That is already enclosed.
Yes,
You
one
want
dash
to
13
enclose
and I'm clarifying, Malad.
Milord, 1-113 is not a subject matter before this and it is not a party that cannot be dragged.
1
into
minute, 1 minute. Just yes. Meantime, you file advance. You serve the advance.
I'll mark my.
Yes.
Monday, already Tuesday, sir.
Yes. 7. This is your understand not to say basing on the instructions in the affidavit. That is not to
No,
but that is only to dissolve the dispute. This
I have not stated.
no. That in future affidavit is
I have not stated you.
No. That is you are correct. Your affidavit, but the parties that's the only intention. Yes. Yes.
Yes, not a number, my lords. That's my issue.
Why from your office the list is not numbered? What is going on?
Only this, it has been written, my lord, by saying that affidavit, verification affidavit is not.
That's you from your office. That is mistakes are come.
It was written yesterday, my lord. That's the reason now I have an issue. So I could not even read it. Lordship, I have it on Wednesday, my lords. Because
My lords, and I have not received any copy also, my lords.
I have been giving them copy to the clerks.
Now now because of these things, now the court is facing very.
Yes, my lords. I agree with that, my lords. But I keep giving copies to the clerks.
Now
my lords.
from you, especially from your offices, the incomplete applications are.
This matter has been troubling us in many other ways, my lords.
Now the
We make a fair submission, my lords. I think
Yes,
the client, because the dispute of 1.5 crore.
I'll send a copy
they
to
will
him
be.
today.
Tuesday.
It's a Tuesday, my number or not number. So watch me have it on Wednesday because Monday is a holiday.
Wednesday is a final hearing day.
Thursday.
Thursday. Yes. At request of the land council for the applicant, post on 16/11/2023. Finally, no further adjournment will be granted under any circumstances.
Yes, sir.
Yes.
My lords, let an advance copy to be served to me, my lords.
I'll serve you a copy, my lords. If he wants to file a counter, let him.
Finally and Japan. Yes.
I'll serve a copy, my lords. If he wants to file a counter, let him file.
Please furnish copy now.
I'll serve it to him, my lords, personally.
Yes, personally.
Yes, sir.
And I will be obliged, my lords, if my friend favors that.
Post on 16/11/2023 at request of the land council for the applicant. Finally, and yes.
Obligement.
Obligements.
Lordship, I wasn't given my lordship. No action was taken against the respondent number 4 by respondent number 2 and 3, lordship.
What action you want against the unofficial respondent?
Misrepresentation of funds, lordship. Misrepresentation of Gram Panchayat funds.
Misappropriation of Gram Panchayat.
Yes, sir.
Who are you?
I'm an Upasarpanch, lordship.
Now, Upsarpanch, now we are discharging as a Upsarpanch in respect to Grama Panchayat.
Yes, lordship.
Are you made any application? Are you given any
I made representation
to the Sarpanch and Panchayat Secretary?
I made representation to
general body meeting,
lordship.
pointing out the irregularities committed by the whether you
I made
Grama Panchayat, how many the consisting of how many ward members? This is a minor Grama Panchayat, Mucharla.
Mucharla.
This is a major Grama Panchayat.
lordship. Yes,
More than 10 ward members are available in the Grama Panchayat.
yes, lordship.
Whether all the ward members are making similar objection, delegation against the Sarpanch. This is a political rivalry between the Sarpanch and Vice Sarpanch. Sarpanch.
No, lordship. I made a book.
Are you submitted? Are you obtained any information? How
I made a representation to collector, lordship, regarding this misrepresentation of funds.
No, how we are going to say the Sarpanch misappropriated the funds?
There's a bill, lordship, without any dates. It's in the page number 19, lordship.
Who issued? Who
Page
issued the
number
bills?
20. Sarpanch, lordship.
Not Sarpanch, Panchayat Secretary.
Yes.
Please see. Who is the competent authority to issue the bills under the Panchayat Raj Act? Sarpanch or Panchayat Secretary?
Panchayat Secretary, lordship.
Yes. Now, whether the Panchayat Secretary was made as a party respondent?
Yes.
Where? Now you filed the petition against the not Sarpanch.
Against the respondent number 4, lordship.
How? Now the unofficial respondent discharging official duties, they issued the bills. Now we are made you file this petition against the person, not against the Sarpanch. Who is the Tejavat Rajita?
She's a Sarpanch, lordship.
Yes. Whether the petition is maintainable against Rajita.
Yes, lordship.
How?
She's issued a check, lordship, 58,000 something.
What do you say?
AGP for who? On request, I am updating.
No, this is not permissible. You are making some allegations against the Sarpanch, not Sarpanch, against the Tejavat Rajita. Are you obtained any information? This is a bill.
In my affidavit, I stated, lordship.
Who is appearing? Unofficial respondent. Who is a Gram Panchayat Standing Council? No. very upset. Now this Kishore Rao, Ejavat Rajita, because of it.
That's not the matter,
You
Lord.
are not included the Grama Panchayat standing as a party respondent. Will grant liberty to the petitioner to file a specific petition by impeding the Panchayat, Grama Panchayat as a party respondent. Yes. Number 1222, 4 of 2022. Yes, please. Land Council. What's your good name?
Shravan Kumar, Lord. Shravan Kumar.
Please confirm.
Can you pass out the matters in my senior?
Grant liberty, informed your senior, nothing will happen. Yes. Yes. Now you're not implemented the Panchayat secretary as a Grama Panchayat. You're not made the Grama Panchayat as a party respondent. You're not made the Sarpanch as a Grama. You straight away file the writ petition against the person, not maintainable. Yes.
April.
Yes.
Sorry, Madam, last occasion I was represented that the work was entrusted to the unofficial respondent. In fact, I inquired into, the matter was not entrusted to the unofficial respondent. It was not given anybody.
Anurag, what is the issue? Tender matter.
Tender matter, courts cannot interfere.
No, that you are coming with a new argument. That is an altogether different on merits. What is the issue?
The issue was there was a project that was to be given.
Adi kaadu. Tender matters, court is not having power to interfere.
Yes. That's my time to see. One contract, tender matter, it can interfere. Contractual matters.
Contractual matter also. If the respondents violated the terms and conditions of the tender condition, that when in spite of the same,
then it can interfere.
Like this. Now, what is the issue? First, you tell the fact.
Let the petitioners explain, Millers.
Yes, what is the issue?
Issue matter pertaining to matter experience.
You are not having case file.
No, Millers. In fact, they didn't even serve it. There's an extra copy.
The lodgement taken up on Tuesday, Millard.
No, why Tuesday? No question. Yes. This one, court officer, work event.
Lodgement, the judgment rendered by the Honorable Justice Kodandram.
What is the issue? What is the issue?
The petitioner having the two special plans.
Yes.
They have not considered that aspect, not considered my tender bid.
When the tender notification issued?
That extent when you lost my also handicapped with the file. And also judgment rendered by the San Court, similar fine.
No. When the tenders were issued,
tender notifications of the date 16/12/2021, Millard. 16/12/21. The application filed by the petitioner is on 30/12/2021.
30/12/2021.
It's the last date of submission of tender, Your Lordship.
Now the tenders were finalized?
Yes, it's finalized, Your Lordship.
Awarded yes.
Para 4, Your Lordship.
Para 4, yes. Tenders schedule open on 5/1/2022.
Right.
Yeah, please read, yes.
The price paid is.
Madam, please come and argue this side. The Land Council also will aware what you are going to say. Srinivas garu work koncham please. Court officer. ఈ మిడిల్ లో ఇంకొకటి పెట్టడానికి చూడండి. ఇటొకటి అటొకటి మధ్యలో. ఎస్ మేడం కది చూడండి వినబడుతుందో లేదో. ఎస్ మేడం ప్లీజ్.
Price paid is open 16/3/2022. The delay is due to process of evaluation and getting subsequent technical bids. The price is not open for the reason that the batch mix plan specified in the decision certificate submitted by the petitioner is not in working condition. As per the report of the executive engineer, Panchayat Raj.
Now there is, madam, that is not required. That is an issue before this court. Now whether the tenders were finalized, the work awarded to anyone. whether the work awarded to any successful bidder.
It was awarded.
Where, where?
May I take my lords to the writ petition page 8, para 6.
Page number?
Page 8 of the affidavit.
Yes.
I submit that petitioner also made application. My lords have got 6, my lords. I submitted, admittedly, the petitioner is having 2 plants within the distance. The fact remains that
That is
petitioner
not required. Now, what is the status of the tenders? Whether the work awarded to the any person successful?
Not, my lords, I inquired recently.
One minute. Madam. Oh. So everyone responsible. Nowhere stated what is the period of contract. What is the period of contract? From which period to which period?
it is only not opening the tender, my lord.
No, not opening the tender. The price bids already opened. Now, whether the work awarded to the successful bidder, what is the tenure of the contract? On payment of costs, both petitioner council, respondents council, one to the legal service authority, one to advocates association. All are responsible.
Tender price bid was opened on 16/3/2020.
Here, opening of the price bid is not the criteria. Whether the work awarded allotment.
That's my passover, I'll ask my client.
Yes, Passover. Passover, yes. Yes. Yes.
In this case, in the day before yesterday, the accused case, day before this matter. I only brought your notice, then I leave the notice. My grievance in the present inspection is that against inaction of the Gram Panchayat is not taking against an illegal construction, though it was, they have specifically stated that there is no permission obtained by the fourth respondent.
Who are you?
Not, I am the one of the shareholder of the property in which not he has constructing the compound wall.
Shareholder
of the property.
Whether the Gram Panchayat is having a power to allot your share.
No, I'm not. Yeah, I'm not. I'm not agitating the title or the any dispute with regard to the property.
Yes.
The
What
question
they
is,
What is your contention ground? What they stated in the counter?
they stated that the construction was made in 10 years back, and recently 3 years back the compound were also constructed, but there is no permission for both of the.
Now, whether you are having to seek demolition of the property house which was constructed 13 years back in 2023.
Lord, you must kindly see once it's a construction is which is made without obtaining any permission is always.
No. Whether the petitioner is entitled to make that plea, the construction made by the unofficial respondent in the year 2012 is illegal without having any valid permission. Whether he is entitled to file a writ petition in the year 2022, whether delay and latches are applies or not, whether any bona fides, whether just academical purpose, it will help to the other cases.
Yes. Because there may be some delay in approaching the court for day, but there's authority have to take action.
How can now if you are going, your argument is going to be accepted. Now the authorities have to demolish more than 60% of constructions. Now why 10 years, 50 years back also, 100 years back also.
Otherwise, the illegal construction will remain without there being any.
Illegality cannot be perpetuated.
Yes,
but similarly, the person who is having any semblance of right, the person is not approached the court within the reasonable time. That is also.
There may be some delay because
not some delay. 12 years. Adverse position also gone.
Adverse position, you lost my kind. I'm only asking them not to take action.
Now, why you are putting a pressure? Why you are putting a pressure? By considering their objection,
but in fact,
that is not permissible. You are having in a good case by filing suit for declaration, recovery of position, mandatory injunction before the competent civil court.
One submission, page 16, but there was an inquiry not directed to be conducted by the
Merely because of Sundaresan client is having some political background,
No.
full power, they will initiated the inquiry. That is not a ground.
It's not a political ground, right? It's not.
Now,
Inquiry was conducted based on the complaint given by.
Respondent says that the unofficial respondent made construction 12 years back. Whether the petitioner is having any right for seeking removal of the particular constructions made 12 years back. We show any judgment from any court.
And as Lordship rightly pointed out, the illegal cannot be persuaded, but
now you file a still that is helpful to the in Hyderabad surrounding city. If your argument is going to be accepted, now including DL Pandu also violated, constructed now 10 years back. Now he is also a sufferer.
May dispose of the petition, not the direction to the work out my remedies before the appropriate.
Yes.
That may be not the as an
NP 23155 of 2022, Telangana Council. It six punch of after argument. Yeah. Yes. Yes, Srinivas. Yes, yes. Who is appearing? Fisheries Department. Yes, you are here, madam. Yes. No. Printing of name. If you are special, you want special invitation, we direct the registry to print your departmental name with bold letters. Are you received the case papers from the Kudumala Srinivas or not? Land Council 31/10/2023 case papers were received. Whether you are communicated the filing of the contempt case to your officers or not. Question of show any provision in the Contempt Courts Act. Notice is required. Prayer notice is required. Now the Land Council already is here. Land Assistant Government Period Fisheries appearing. Land. Work to the registry does not arrive. Really, there is no contempt. This court will dismiss the contempt at threshold. If there is any contempt, no, the Land Standing Council. Yes, already gone. Yes. Serve one set of papers for the land. Yes. Next time you are not entitled to say your name is not printed. Printing of name arises only after filing of the wakalat in contempt cases. Only this name only for the convenience of the court. You are the counsel representing the department, not against the person. Yes. Whether your department committed any irregularity or not complied the condition order, not by XYZ. Yes. Yes, fishery. What do you say? Now only this court, the other learned judge, this court directed the respondents to consent representation, pass appropriate orders, giving opportunity. What is your problem? If the disputes are there, the dispute has to be resolved. by invoking the provisions of Cooperative Society Act, you have to say, yes, yes, no representation on behalf of the petitioner, land and government feeder fisheries, seeks short adjournment for getting instruction at a request post on 17/11/2023. Yes, you already filed wakalat. How you file wakalat? Even before ordering notice. Yes. Yes.
I beg to represent on behalf.
What do you say, Madam Fisheries? Where is the rejection order? 1 minute, they will furnish. Yes, furnish copy to the land council. Yes, court office is coding. Madam, CC 2441 of 2023. Petition. Yes. That's a picture. Yes. Grama Panchayat filed contempt case against the bride. Yes, madam.
So the response be able to. Actually, the file is not misplaced here. Should kindly have 2 weeks fine.
No, your client violated the orders of this court. Land Council. What's your good name? Vani. Yes. Get ready. Yes.
Your lordship can have after 2 weeks, my lord.
Why?
Will verify, my lord, because it's
ఈ పాత కేసులు ఎలా మరి ఎలా చేయాలి? How? Now the young councils has to cooperate, not to give burden to the senior councils, especially designated senior councils.
you need to verify with the client also, because it's a very old.
Land Council. What is your good name, Swami?
Ravi Kumar.
Ravi Kumar, initial?
K.
K. Ravi Kumar. Twenty-three 11/2023. Registry is directed to print the name of CC లో 488 of 2023. Rangareddy, P. Kishore. Cases, yes. రెండు కూడా 38 లోనేమో పిటిషనర్ పేరు కిషోర్ రావు, 39 లోనేమో కిషోర్ రావు జీ. ఎస్. Yes, Panchayat Raj. Where is government period? Panchayat Raj. Yes, madam. Now you have to take responsibility, request your officer to depute one officer Thursday, Friday in court. But no question of adjournment, simply. Contempt case between the petitioner and contemnor. Collect from the court, you inform to your clerk, go and collect the case files from the section. We already given in necessary instruction. No, every day this will definitely take responsibility. Government is only one chief secretary, one principal secretary. That is not a ground. Yes, no representation on behalf of the petitioner at the request of the land assistant government pleader, Panchayat Raj, post on 17/11/2023 under the caption for dismissal. Yes. To give an opportunity to the petitioner, post on 17/11/2023 under the caption for dismissal. In the meanwhile, the land assistant government pleader, Panchayat Raj, shall get instructions. Yes. Please inform. Yes. Anyone representing Jyoti Kiran? Yes. No representation on behalf of the petitioner to give one of. Yes, yes. Yes. your land acquisition department also required adjournment. Yes. Anything otherwise? Entry model. Yes. Land assistant government paid a land acquisition. Yes, 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 no, no, yes. Yes. Yes, Ram Babu. Yes, no representation on behalf of the petitioner. To be. Now, Dammaiguda already municipality. Huh? Municipality get inside. Just yes. Yes. ఎట్లా మరి పుల్లారెడ్డి గారు now who is taking care of the Pullareddy గారు office? Yes, no representation on the of the petitioner to give one opportunity post on 17/11/2023 under the caption for dismissal. They in the meantime this is a with the secretary Pragati Nagar residential general secretary. This is a dispute between the petitioner and respondents. Your private dispute.
We are private response.
Yes. The London Council appearing on behalf of the respondents seeks short adjournment for getting instructions post on 17/11 for dismissal and TCN. Yes, to give an opportunity posting. In the meanwhile, the London Council appearing on behalf of the respondents shall get instructions.
This matter with Bharat has appointed a AGP, but they have no objection to Wakalat. Party informed him, I filed Wakalat.
The London Council. What is your good name?
Nambi Krishna. Nambi Krishna.
Nambi Krishna.
We need to get instruction.
No instruction. We are here. No fresh instruction. What is the issue?
Not to interfere.
Are you interfering?
It's the order.
Now will it?
I gave your lordship.
Now we'll close. Record it.
13 your lordship.
Oh yes. No. The contempt case. No. Your argument is correct. Now the contempt case, as per the provisions of section 10 to 12 of the Act, they have to file within a period of 1 year. 1 year. This is the principle applies to the final orders, not interim orders. The petitioner, the petitioner filed in a contempt that you are interfering in the year 2018, that is 2013.
2013.
Yes, 2008 order. The official respondents are interfering with the position in 2008. This is a construction, not to interfere with construction. How the 2018 or 2013 interfere?
We are creating a wall, lordship.
Not compound wall.
Compound wall.
Compound wall, no permission.
Yes. And that
We have filed two writ petition, lordship. We have filed.
Yes.
We will get instruction whether colleges survive or not next week.
M. Srinivas, your name? What is your good name?
Muhammad Ahmed.
Muhammad Hamid, London Council. Hamid.
AME.
You have to appear, not senior. Why you are giving trouble to the seniors for small issues? It is request post on 17/11/2023. Finally, no further adjournment will be granted. Yes. Get ready with all weapons. Yes. 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 CC 773 of 2015. The petitioner under him. Yes. 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 Already rejected. Yes, sir. Yes. CC 936 of 2015. Petitioner filed this contempt case for non-implementation of the orders passed by this court dated 13/11/2014, invoking the provisions of section 10 to 12 of the contents of 2015 order, 2023. Yes, the petitioner is granted liberty to serve, avail the remedies as available under law. If so, advise. Yes. Yes.
Wait, please, your lordship, this content can be closed.
Yes.
Because the
CC
weighbridge has been shifted from that place.
CC 1. Monday, Tuesday for sale. This is against the entry model. Now the petition also can be closed. Now the already your grievance resolved. Now your grievance laying of the weighbridge in your land.
Yes,
Now they are already shifted.
Yes,
now
Lord.
the repetition కూడా ఏముండదు.
Yes,
repetition depreciation ఇవన్నీ close చేయొచ్చు. The 32375 of 2014. Today we'll close the repetition. Now that is your relief. Main repetition, your relief is.
I'm handing up with the petition file.
No, repetition.
I'm gonna have it tomorrow.
1 minute. Just repetition. Page number contempt case. Page number 18. Page number 18. affidavit starts from page number 13. Page number 12 is a prayer. Unanimous declaring the action of the respondent for taking action against the respondent with regard to construction of undertaken by them in the land of the petitioner 0.11 guntas in survey number so and so without obtaining any permission. Now now we'll close the petition also. Yes, it's very well. WP number 32375 of 2014. The pitchy closes. Right. I'm obliged. Right. Yes. Page number 12 on the prayer. అంటే సిసి చేయొచ్చు బోత్ చేయొచ్చు అంటే కామన్ అంటే అది రిపిటిషన్ లిస్ట్ లో లేదు ఎస్ ఎస్ రెండు క్లోజ్ చేయొచ్చు కామన్ ఆర్డర్ రాయొచ్చు మేడం
Password.
మేడం
Requested for password. 50 and 50.
50 and 54 we are representing
Us.
or Sridhar anyone representing on behalf of the respondents password yes 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 52 53 already urgent 52 53 Bhanu Prakash you not they are not informed some is someone no 24 they informed that already informed to the respective council one council yes we 38 okay నిమిషం ఆశీషారా we will take care on that yes yes
I think 54 is contempt case.
ఇంకా పిలవలేదు 54 పిలవలేదు
The connected repetitions are there enough that so no further orders are required once the repetitions are 75 and
Kasim,
75 75 76
they are connected to anyway once the repetition is disposed of nothing.
Now you want closure of the contempt now the after this along with it yes.
Once the repetition is disposed of
court officer గారు ఈ contempt 75 76 తో పాటు పిలవండి
అప్లికేషన్ లో 1BROR అని చెప్పి మెన్షన్ చేసిన దాన్ని అదొక కాపీ
యాదగిరి గారు వాట్ యు వాంట్ yes
మనతో కాపీ ఉంటది కదా
యాదగిరి గారు ప్లీజ్ yes yes 12/11/2014 order you filed contempt 2016 how within the period of 1 year yes now because you are also appearing on behalf of the ground municipality yes CC 20 Court officer, post WP 34007 of 2014 on 16/11/2023. Yes. Yes. Admit. చెప్పండి పోస్ట్ చేయమనండి తీసుకో. Yes. 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 Not required. Yes. CC 52. Contempt case, whether this court can say no. Is required according the contempt case is closed. Yes. Yes. Yes.
Worship petition counsel requesting for 1 week time.
Why you are here?
He was out of state.
You are here. What is the issue?
Construction of the drainage. I'm not awareness of this fact. I don't think
Yes.
I told this one.
Yes. What is your good name?
Kalpana Mala.
Kalpana Srimati. Yes. Yes. Anyone representing Udayasri? Password? Yes. Yes. What do you say, Ravi? Are you not implemented?
Not implemented.
What is the nature of order?
There is a direction to dispose of the representation.
Madam, your officers are on, I will not time to pass the order dated 27/7/2016. Consider the representation. No verification. This court is going to admit the contempt. Now the only principal secretary. No tomorrow. This last occasion specifically posted to today for getting instructions. This court only passed. What is the nature of order? Inauspicious orders. Consider the representation and pass appropriate orders within a period of 8 weeks. First respondent is hereby directed to dispose of the representation of the petitioner, which was forwarded by the Chief Secretary Agriculture through letter dated 21/8/2012, as early as possible, preferably within a period of 2 months. This petition was disposed on 27th July 2016. We are in 2023. Password. No question. Otherwise, this court is going to admit the contempt case. Your officer will get 4 weeks time. Yes. Password. Yes. Yes, Prabhakar Rao. Passover. Yes. Kelkani Venkata Yadav, are you representing? Yes, what are you? The civil side, yes, books are even file even.
61, madam.
51. Yes. Open the locks, seized rice mill. Are you implemented the orders passed by this court?
Yes,
or
ma'am.
not?
Yes, ma'am.
Waste.
Implemented, madam, but the memo is pending from officer, madam.
Passover. Civil Cell Corporation
We have been
situated
trying from
Somajigada.
yesterday, madam.
No, Passover. Nothing. Get insights. Listen, you use technology, get the proceedings from the office situated in Hyderabad only. Yes. Passover. Yes. It may be close to. Yes. CC 299 of 2020.
They have not implemented it actually, but there is no point in
Now the
proceeding with
contempt case only two remedies: implementation, non-implementation. Yes. 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 Complaint. Yes. Where you are stated. Are you released? Where you are stated released the stock. Further, as per the orders of this court, honorable court, the assistants directed to release the seized stock to the owner, duly verifying all the documents. Where is the release? Respondent collector shall release the seized stocks and furnishing. Further, owner of the vehicle has submitted surety with an undertaking affidavit stating that he will not sell or lend. What happened 6A proceedings? Yes, no representation on behalf of the petitioner. You have not implemented the order. We'll see what he is going to say. Yes. Why your officer not furnished the said information in 4 pages note? Yes. 7011 dismissal. Yes.
Sure, doesn't give it now. CC matter.
Not implemented. Are you sure?
Notice was not sub lordship.
Yes, madam. Civil supplies. Now this matter already adjourned on 3/11/2023. Land assistant government period civil supplies. 6.
My lord,
Yes.
happy for the applicant in this matter, my lord. Should may recollect this matter was already heard by the honorable court, my lord.
Court memory is very less. You argued the matter 1 year back.
My lord, I may permit to initiate my argument. My lord, the petitioner's hearing, my lord, have entered into a letter of intent and as well as agreement of sale with the respondent's variant.
1 minute. 1 minute. Yes. Now the everything is completed.
My lord, yes, my lord. As of now, my lord, the matter it happened so.
No. This now this pleadings are completed.
Pleadings are completed as of
Now
now.
everything.
Yes, my lord. Yes. My lord, may kindly take my lord page number.
Last occasion you said something.
Yes, my lord. What happens when this
all the
objections are all completed, my lord, as of now?
Everything is in
order as of now. Yes, my lord. My lord, my lord, here is a case where.
1 minute. No. Whatever the papers which are filed, this is nothing but in the original side proceedings.
Yes, my lord.
The other council also.
No, I have not filed any. My lord. I have not filed any. No, it has been returned. It has been returned. It has been returned.
There's now today in the cause list only one arbitration application is.
Yes.
No, he's not pressing that.
I have not filed it.
Not proceeding further. That IA is not submitted. Yes.
No, the reason for me to file that application is I may illustrate. No.
Reasons are not required.
Yes,
for adjudication of the case.
The present arbitration application is filed, my lord, paying the honorable court, my lord, to appoint an arbitrator, my lord, for the enforcement of the contract That is my agreement of sale and as a letter of intent.
Step required for both.
So I may take not less than 10 minutes.
Just only other counts can attend before other courts. That's only.
10 minutes, I mean, it may come to 10 minutes.
Yes.
Page number 39 is the letter of intent, my lord, may kindly take.
Page number
39 of the compilation. Document starts at page number 39.
Yes.
My lord, I may straight away refer to page number 45 at point number 9.
45.
Page 45.
Yes.
Point number 9. That is dispute in the jurisdiction. If there is any dispute arising out of these heads of terms, including with respect to the validity or enforcement of the same, the parties shall refer the same to arbitration and the Arbitration Conciliation Act 1996. The arbitral tribunal shall comprise of a sole arbitrator to be mutually agreed between the parties. The venue of arbitration shall be Hyderabad and the language shall be in English.
Yes.
But this is the arbitration clause of the agreement.
Yes.
Now, after the letter of execution of the letter of intent, there were certain payments made by the petitioner, by the applicants here into the respondents.
Yes.
Now, thereafter, document number 2 was executed. No, that is agreement of sale. That is starts at page number 52.
Yes.
And this is an agreement of sale, entered between the parties wherein amounts have been made out, the amounts have to be paid to the parties, and the area is also demarcated. I may emphasize upon paragraph number page 57.
Yes.
The last paragraph I may refer to. And whereas the vendor being the AGPA holder of the entire property, now the vendor referred in the present agreement, in the agreement of sale is the respondent herein.
Yes.
Has executed a registered sale on itself to a registered sale deed bearing document number 16/120 of 2015 dated so and so, registered before the sub registrar of Rangareddy for the land admeasuring 15,355 square yards. Out of total land admeasuring 4 acres 2 quintals covered under survey number so and so instituted at Raidurga, sharing in Pali Mandal, Rangareddy district, which is clearly described in schedule here 2 and here we call it schedule 1 property.
Yes.
And by this statement, it goes to show that the respondents here are the owners of the property.
Yes.
Page number 55, the top paragraph I may refer to. And whereas the purchaser who desired to acquire spares in locality has inspected the schedule 1 property, the design, the type of accommodation and amenities thereafter, and on being satisfied with the title of the vendor, selected the unit 504. This is the scheduled property when referring to in the present case.
Yes.
Unit 504 on 5th floor with a super built up area of 25,899.81 square feet, built up area so and so, along with 25 car parking lots in cellar number 3 of the above said Sandhya Techno 1 office building complex belonging to the vendor. Approach the vendor for its sale along with the proportionate undivided share of land equivalent to 310.78 square yards.
Yes.
Now, this is a schedule of property mentioned so purchased by the applicant's herein from the respondent's herein.
Yes.
But I may straight away take my lordship attention to page number 61 for a moment. But there is a liquidated damages clause incorporated within the agreement of sale, and also, my lord, the letter of intent was made part and parcel of the agreement of sale. Now, page number 61 for a moment, my lord. Point D1.
Yes.
In case of any delay in handing over above soft services beyond July 31st, 2018, for first 15 days.
Contract between the petitioner and unofficial
It's an agreement of sale.
Agreement of sale?
For the purchase of the property, which I just read out to this honorable court.
Yes.
First, there was letter of intent entered between the parties.
No, that is also an arbitration agreement clause in open. Agreement of sale?
But agreement of sale doesn't contemplate arbitration clause. Letter of intent does. Now, in the subsequent document, there is a reference.
The dispute between the petitioner and unofficial.
Dispute is, my lord, I have been not at all hand. My amounts have been paid. Substantial amounts have been paid by the applicants to the respondents.
Why was not the agreement of sale?
Yes, my lord. Substantial amounts.
Yes.
The building has to be completed, but building has not been completed.
Development agreement.
Yes, my development agreement. But I am not a party to development agreement. I am only a purchaser of a share of a portion in the 5th floor. 504.
From whom?
From the respondents here. That is the reason, kindly I have just read it out. Page 57 tells the title of the respondent number 1 herein. Page 58 is my proposed the purchase of the property, that is unit 504, my lord, page number 58.
Just to only, first you give the facts. So what is the, now the, who are the applicants, who are the respondents, what is the nature of dispute between the applicants and the respondents?
No, applicants are the, my lord, applicants herein are the agreement holders of the respondent herein.
Yes.
Respondent herein, my lord, were proposed
Holder in respect of?
in respect of one portion in the building, proposed building to be constructed by the respondent to 1 and 2.
Right on the date of execution, there is no property.
No, as on the date of execution of the agreement of sale, there was a proposed plan and the structure has to be laid.
Yes.
My lord. So, my lord, when the letter of initially the letter of intent was executed between the applicants and the respondent herein, wherein, my lord, the parties have agreed for a sale consideration amount for the purchase of that particular portion of the property.
Yes.
My lord, subsequently, after letter of intent was executed, well, you kindly see the letter of intent for a moment, where it bears all the applicants. There are altogether 12 applicants, my lord.
Where is the letter of intent?
Letter of intent starts from page number 39.
Yes.
The purchase, my lordship, got it, my lord.
Yes.
In the top, you can, my lordship, see to Sridhar S. Rao, managing director in Sangha Hotels Private Limited.
Letter of intent, agreement of sale, when? Letter of intent?
Letter of intent, my lord, is 19th January 2018.
Agreement of sale?
Agreement of sale was entered on
No date.
April 2018, my lord.
Where is the date?
Date, my lordship, we have to rely upon the stamp paper, my lord, that is 16th. Same, very same date.
Whether under the stamp paper, suppose the stamp paper purchased. 2016.
2000.
Suppose.
I agree, my lord. I agree with you, my lord. But in this case, my lord, as of now, date is not specifically mentioned in this matter.
Neither date. No, in the signature column also there is no date.
Yes, ma'am.
Yes.
So, but it is, these are all admitted facts on record.
Yes.
But after the letter of intent, my lord,
Yes.
under the agreement of sale, substantial amounts have been paid. There is a schedule fixed, my lord.
Yes.
And my lord, you may see the schedule in the agreement of, in the letter of intent as well as in the agreement of sale. I may show up on my lord.
Construction completed?
My lord,
Just it one.
here it starts, my lord. Well, as per, well, that is the entire case. Well, at the time when I entered into the agreement of sale, later on it was brought to the notice of the applicants here in that the building which was constructed, Miller, was completely violated. They were under the consent GHMC Act.
Eyes on the date of entering the agreement of sale or date of letter of intent, your clients have not verified those plans.
Well, plans, etc. Well, see, we were the bona fide, madam. But there was a building proposal being made out.
Yes, yes.
But we were to be purchase of that particular property.
Yes, yes, please proceed.
Later on, when after the agreement of sale, it came to the knowledge of the applicants here in that, my lord, there are illegal construction deviations made out by the respondents on 2 and 3.
Yes, yes.
Now, wherein the portion of the building was already demolished.
Yes.
My lord.
Yes.
Now, as of now, because it has come out from the mouth of the respondents herein, certificate has been obtained. But till date, my possession, my property was not given it to me under the agreement of sale. So, my lord, I am before the
dispute. Your claim is that according to the letter of intent or according to the agreement of sale, the applicants paid total valuable sale consideration.
substantial, my lord. There are certain amounts to be paid. That is very meager amount.
It's not handed over the position.
Specific performance. I am seeking specific performance.
That is your.
That is my entire case.
Where is the arbitration clause?
The arbitration clause, my lord, it's in letter of intent, my lord. Page number 45.
Page number 45.
Para number 9.
Now, according to the letter of intent, has to be termed as the agreement.
No, there is not. Letter of intent has to be read part and parcel with the agreement of sale. The agreement of sale, my lord, please to see. I may emphasize the point, page number 62, point B.
Yes, yes. Now, that is a dispute.
Okay. Kindly see, because
are they stated in the counter affidavit?
they say that they have not answered any of the allegations which are made, contentions which are raised by the applicant in the arbitration application. They said that they reserve the right to file appropriate counter at that point of time.
Where is the statutory notice issued by you?
Yes, my lord, first statutory notice got issued to me.
Now, pursuant to the clause number 9 of the letter of intent.
My lord.
Now, you are initiated the proceedings invoking the provisions of the Act.
Yes, my lord. Section 11. Yes. My lord, first notice, my lord, page number 73 it starts, my lord.
Page number?
73 of the compendium. Compilation.
Yes.
My lord, may got it, my lord.
This is only legal notice.
Legal notice, yes, my lord. English, my lord. We have made it at paragraph number 8, my lord. Paragraph number 8 of the page 76, my lord.
Yes.
My lord. 8. We therefore hereby call upon you to complete the works and hand out the premises described in Schedule 1 and Schedule 2 of the sale agreement dated so and so as per terms and conditions contained therein.
Normal legal notice.
Yes, my lord.
General notice.
General notice, my lord. The invocation of arbitration clause in second notice, my lord. Page 95.
Page number?
95 it starts, my lord.
Whether the pursuant to this legal notice, respondent issued any reply?
Yes, my lord.
Not this.
My lordship, no, second notice they got a reply, my lord.
First notice, no reply.
Yes, my lord.
15th November 2018.
First notice, no. Second notice also there is no reply, my lord. But in fact, even for third notice also there is no reply.
Yes.
Page 105 is the arbitration clause wherein I have invoked, my lord. Page 105, that is third notice.
Page number?
105.
Yes.
Page 111. Para 9. Hence, you are hereby called upon on behalf of my client to execute a registered sale in favor of my client in pursuance of the letter of intent dated so and so, an agreement of sale dated so and so, in respect of the property, that is unit 504 on 5th floor with a super built up area of so and so, and so and so, along with 25 car parking slot and so and so, so and so. My clients are entitled to liquidity damages. Even in this very notice, I proposed 3 names of the retired High Court judges.
Notice, any reply?
No reply as of now.
Notice served?
Notice served. I have filed proof of service, page number 113 and 114 to 16 are the written covers.
On the, what is the endorsement?
Endorsement, my lord. No such person. And so him. Addressee absent, my lord. For one such notice, no such addressee.
Where is that endorsement?
My lord, I have the originals with me, my lord. It may not.
Why you are not file? Only you file one side information, second side.
My lord.
Why?
I don't know. It is with me, my lord, for the clarification.
Whether they are disputing?
They are not disputing on that aspect.
Yes.
They are, may kindly see the counter for a moment.
Yes.
They have not even traversed to the issues which have been raised in the arbitration application altogether.
Yes.
The objection, primary objection which they take up in this matter is, my lord, that the agreement of sale has to be properly stamped.
Now, by virtue of that is required.
Yes, my lord. Now, my lord, earlier submission, my lord, may recollect. The 5-judge bench of the Honorable Apex Court, my lord,
yes,
wherein the law has been there were differing judgment in the judgment, wherein 3 judges have conceded to the point saying that the Honorable High Court has to send the document or the measures have to be taken for that, seeing that the document under which the agreement of document under which the arbitration clause is relied upon should be impounded. But 2 of the judges have differed, saying that the document has to be the exercise of impounding of the document can be looked on by the arbitrator. Now, my lord, that the very judgment of 5 judges is now under before the 7 judges bench.
No, as on today, the principle laid down by the 5-judge judgment is binding.
That is when subject to my lordship that
court and other high courts are also following the large 5-judge judgment as on today.
I am subject to my submissions, my lord. The judgment is under an appeal before the 7 judges benches. I have been representing before this honorable court in other matters, wherein this honorable court, in couple of matters, appointed arbitrators, and couple of in other 2 matters, this honorable court deferred the judgment until the judgment of full bench has been 7 judges bench has been made out. It's a curable defect, my lord. That may not be a ground for dismissal of the arbitration application.
Initiating the proceedings by invoking the Stamp Act, provisions of the Stamp Act, sending.
My lord, because my lord, because see, my lord,
In other matter, the other council, one matter is the state, and other matter, two matters, the parties are taking steps.
my lord, here in this case, I'll tell you, my lord. The registrar stamps duties, my lord, he doesn't until there is an order of this honorable court specifically made out on that particular document. He is not entertaining any register, taking of stamp duty, my lord. It happens in another matter.
You file affidavit to that extent.
I will file already my one affidavit.
No, unless and until you have not made any application for implement of the document.
That application earlier I filed, my lord.
Wait.
I have not pressed that application. In that period, what happened in this matter? The GPA holder whom we have petitioners have engaged.
Now you have to file a necessary application for seeking impoundment of the
Well,
document.
now officers raised an objection that is the application which has been written by the court section saying that the applicants in that the cost study is not matching because I have shown the party was compromised with them in the cost study as respondents. Now the officers raised an objection saying that cannot be allowed until there is an order of the court.
Why you are made an endorsement post before court?
I'll take that steps, but anyway, my lord, now because
You are inviting everything from the court. Now you are without complying that is a requirement.
well, my lord, my submission, my lord,
Today, this is an unregistered agreement. Sorry, the requirement.
deficit stamp duty, my lord.
Stamp duty.
It's already seen stamp paper, deficit stamp paper.
Now the without proper stamp, as per the provisions of section 35 of the Stamp Act, the document cannot be looked into any.
No, my lord, this is a case where
No.
it's an exception. My submission, my lord. It's an exceptional case where even in the suits, my lord, oral agreement of sale, my lord, suit is maintainable.
Maintainable in respect of specific performance of contract.
Yes.
Invoking the provisions of section 49 of the Specific Relief Act.
I do agree.
For limited extent.
My lord, here in this case, my submission before this court is
Now the nature of relief sought by you not specific for enforcement of the agreement of sale.
yes, but my enforcement under the agreement of sale, my lord, please.
Under the arbitration, as per the provisions, as per the amended provisions of the Act, as per the law laid down by the Honorable FX Court 5 Gen, the document is required stamp duty.
My lord, that has been referred to a larger bench, my lord, 7 judges bench, my lord. Even the Supreme Court, my lord, heard the matter expeditiously. Now it is being reserved for judgment, my lord. Judgment is awaiting at any time.
Whether you want to pay deficit stamp duty.
I am ready to pay. It's a curable defect, my lord. My parties are ready to pay.
Now, as on today, this is basing on the
This excess has to be, my submission is payment of stamp duty, my lord, is a defect of curable. It can be cured. My submission is, my lord, let this exercise be done by the honorable arbitrator.
No.
If this court, my lord, then in that case, my lord, I will file the necessary application as of now, my lord. Because, my lord, the matter why it was prolonged because of
the nature of application filed by who that is pending before the registry. Very same application.
very same application.
Why?
Registrar has raised, but not it was written for 5 times, my lord.
Registry may raise several objections. Now, from your office, like your office, now the not proceeding the particular application.
My lord, here is I have endorsed it, my lordship, please if you permit. It was been written 5 times. First objection raised for kindly bear with me. First objection was raised was
Acting in original side also.
yes, my lord.
When this
Here in the matter, what happened, my lord? This matter at the time of filing arbitration application, all the parties were represented by one special power of attorney.
Other side raised an objection basing on the particular agreement of sale. You are not entitled to seek enforcement.
That is only a normal objection, my lord. But in total,
insufficient stamp.
yes, that is the objection there is.
Main objection, that is a main objection. Yes, yes.
That is the main, according to me, that's the main objection, my lord. Because my lord, under provision section 11.
Say what my objections are.
Yes. Now, in counter affidavit, you are raised several objections. Now you are saying one objection.
No, my lord. If my lordship kindly exercise, permit me to read the counter affidavit for a moment.
Yes.
My lordship may ascertain, my lord, what objections have been raised. The other objections, my lord, kindly counter may be taken up for a moment.
Which counter? Now the two count. How many counters filed?
2 counters.
23rd.
Not party to the agreement of sale of the which is taken simply because the director of the company cannot be made a party. His individual capacity. The company represented by such director can be a party member, but the party and individual capacity cannot be a party.
Why not?
Such person is not a party to the agreement.
May not kindly see the letter of intent.
Yes,
Letter of intent answers, May not.
Yes.
Letter of intent answers the query, my lord, first query. Now, kindly let us test, my lord, what are the objections raised by the respondent in the present arbitration application.
Yes.
My lord, the first objection was, my lord, paragraph number 3. It is submitted that present petition is devoid of any merits to call for interference of any relief that can granted by this honorable court, and the submission made here is independent without prejudice.
You are reading which counter?
I am
Rao, Sridhar Rao.
My lord, it is the affidavit of Mr. Sridhar Rao.
Yes.
No, Upper Rao.
Yes.
Upper Rao.
Yes. Para number?
Paragraph number 3, my lord. It says devoid of any merits.
That is not required. That is
Paragraph number 5, my lord.
Yeah, yes.
It is submitted that in this regard, given the scope of present proceedings under the Act for appointment of arbitrator, the present reply.
Actually, what is the main objection? Please concentrate this.
No, my submission is the main objection is, my lord, with regard to that is made out at paragraph number 9.
Not 9, 8.
8 and 9, both goes on the very same footing.
Yes.
8 also, may kindly read.
Yes.
It is respectfully submitted in this respect, prima facie, the petition of the applicant is not material as it is no longer reciting of the letter of intent is not an enforceable document. The letter of intent merely expresses an intention to enter into a contract. There was no binding legal relationship between the applicant and the answering respondent at this stage. In fact, the same is confirmed in letter of intent dated so and so at paragraph number 10 of letter of intent. It clearly states as follows.
Just only academical purpose. What is the problem approaching the competent civil court by filing enforcement of the agreement of sale?
Lord, I am bound by the arbitration clause. My lordship, please see.
Even if the arbitration clause, that is an understanding. Now the no suit is maintainable.
Suit, if you may lordship kindly see, the latest judgment of this honorable apex court made out in Chloro Controls and as well as, my lord, I am unable to get that name. In that judgment, that the Booz Allen case was been referred into. It's a celebrated judgment of the honorable apex court in Booz Allen. And in those judgments, my lord, there are 7 such circumstances have been made out, in which, my lord,
yes, proceed. Yes. Yes.
I don't fall under the seven exceptions which have been made.
Yes.
All the party to this transaction intend that this proposal be superseded by the purchase agreement.
Yes.
In the meantime, all the parties agree to proceed in accordance with terms and conditions outlined in this letter of intent. Seller understands the purpose of this letter of intent is to allow further investigation by both the parties into the feasibility of entering into the formal agreement. The letter of intent is only binding on the parties during the contract negotiation period. Point number 9. It is respectfully submitted that in the absence of valid enforceable agreement, the present application is devoid of any merit and liable to be dismissed. The applicants in their brief written statement referred to unregistered agreement of sale dated April 2018. However, such an agreement of sale which is not registered and requisite stamp duty is unpaid cannot be considered by this honorable court in the present application until such deficit stamp duty is paid through proper impounding procedure. NM Global is referred. With paragraph number 10. Without prejudice to the other contentions raised in the present counter affidavit, it is respectfully submitted that one of the applicants, this is where the mischief played. One of the applicants, applicant number 11, Mr. Sohan Ganate, has cancelled the agreement of sale made with the answering respondent by cancellation of agreements of sale dated so and so. Thereby, the applicant number 11 herein has unequivocally given up all claims in relation to the present application. A copy of the cancellation of agreement of sale is filed herewith for kind producer of the honorable court. Pursuant to the cancellation of agreement of sale, Mr. Sohan Ganate has taken amount of 17 lakhs from the answering respondent. It is pertinent to state that the LOI of the agreement of sale dated so and so was entered into by answering respondents with all purchasers, including the applicant number 1 herein. This statement is wrong.
Who executed agreement?
The cancellation was done by applicant number 11, Mr. Sohan Ganate.
So
Initially, arbitration application was filed.
agreement of sale executed by whom?
Agreement of sale executed by all the parties. My lord, you kindly see agreement of sale for a moment. Page number
52.
52, yes, my lord.
52 executed by
All the parties names have been referred.
where is
12
the,
parties.
where are the signatures?
Signatures, my lord.
Only managing director. Yes.
Sanjay order. Yes, my lord. Agreement of sale. Yes, my lord. Purchases one represented, my lord.
Yes. Now who cancelled this agreement of sale?
Applicant number 11 in the cost title of the arbitration application. Sohan Ganate.
Sohan Ganate is not any party to the agreement of sale.
He is a party, my lord.
Where?
Party number 11. Page number 53, my lord.
Where is the signature?
Signature, my lord. Yes, my lord. I agree. There is no signatures.
Now, mere mentioning the party's name in the agreement of sale, that is sufficient. Just under law.
Under, my lord. I didn't got you.
No. Mere mentioning the party's names in the agreement of sale, that is sufficient without any signatures.
Well, agreement, that's what my submission is. Agreement of sale is not, my lord, until the sale is executed. Even oral agreement of sale also pertinent intimate.
No.
My submission.
Sir, in the absence of any signatures of all the parties.
No, that is not been specifically denied even in the counter in the arbitration application.
Now, during the course of hearing, this court is in a painting of.
My lord.
What is the law?
Not.
No.
Usually, agreement of sale will be executed by both vendor and vendee. I concede to that point.
Now, the mere mentioning of the party's name in the agreement
But there is one representative who, Mr. Osumene, now he is signatory to the again a letter of intent, but I have to ascertain who has signed the agreement of sale.
Ascertainment of after filing pleadings are completed during the course of hearing several. Now, this ascertaining is not permissible.
I agree.
Yes. No. Yes.
Because not the admitted fact as on record is not all the parties, but that is the applicant's hearing.
Person who is not the signatory to the agreement of sale. Now he cancelled this agreement of sale.
Yes. Yes, my lord.
Yes, very yes.
It goes, my lord. The facts of the case goes. But that gives an implied.
Not pointed out that.
Even I didn't. It has come to my mind this time. Even I didn't. This came during the course of the application. Now, my lord.
Madam, this is only agreement. Any other agreement is there? This. What do you say? They not required all the party signatures. Just only this.
No, in the agreement of sale only, the signatures itself, my point out, my lord, that it is signed by one Srinivas. There's no authorization in favor of Mr. Srinivas. But the agreement itself says
No,
it is to be signed. The agreement, my lord, at the end of the party says presented by Nagaratna Hosman, who has not signed on behalf of the parties.
Now your client not signatory to the agreement of sale.
My client has signed, my lord, which is why there's no denial.
No. Sohan Ganate.
No, he was.
No. Sohan Ganate is not.
Was one of the applicants. After filing of the application, he is settled dispute with respondent.
No, he is not the signatory to the agreement of
Yes.
sale.
Yes, ma'am. So
now cancelling of the agreement of sale in respect of his share is also not permissible.
My lord, except for the fact that point 5 of the cancellation document, he has undertaken that he will be withdrawing this arbitration. To that extent, my lord, since for the purpose of section 11, it's a limited scope.
Now the applicant he wants to withdraw.
One of the applicant.
Yes, one not in respect of his share. Yes.
Respect, my lord.
Now this is a very good case for learn the several
Tristan tells me lord.
Also, my lord, if that circumstance is a joint and several applicants and who is the
yes.
That circumstance, one person has cancelled the document, then that is possible to send all of them, including that person, for arbitration? And can it be binding on, can it be subsequently continued binding? Those are all questions for the arbitrator, I can. Well, one other point. The prayer in the arbitration application, they are seeking the appointment of an arbitrator as per the letter of intent.
Yes. Yes.
The prayer itself says only as per the letter of intent. They don't mention the agreement of sale. Letter of intent, my lord, down to Supreme Court has said in multiple cases it is not enforceable. In the letter of intent itself says it's not enforceable. That it is only for the purpose of further, if you've seen those clauses, my lord, as extracted after, that it is only valid for a particular period and only for the purpose to enable the applicant's hearing to further do their due diligence.
Yes. Yes.
May I, Milord?
Yes.
Let her conclude on the aspect.
No. Just you.
But in answering to
Now
that
you have
particular.
done it. No, you say 15 minutes, now the more than.
Milord, it has it is interesting twist and tales in this case, Milord. What to, it happened so.
Yes.
Lordship, kindly see the agreement of sale point number I was just referring to earlier. I may refer upon because page 62 for a moment.
Yes.
62 point B I may be referred to.
Yes.
The terms agreed in the letter of intent dated signed by the vendor and purchaser will continue to remain in effect to the extent that it is not contrary to this agreement of sale to show the intents of the parties. But I may rely upon section 7 of the Act. Section 7 of the Arbitration Act speaks about an arbitration agreement. No.
Yes. Court officer. Arbitration Conciliation Act 119. Yes.
No.
Yes.
Under the arbitration, the arbitration clause is made out in letter of intent. Letter of intent is made part and parcel of the agreement of sale.
Yes.
It is not the case where agreement of sale supersedes the letter of intent.
Yes.
My case before this honorable court is Milord, and by virtue of point number being made out in page number 62, the letter of intent has to be read part and parcel of the agreement of sale.
Yes.
Now that apart, now point number 4A for a moment we taken up, Milord, in the very page 62.
Yes.
The purchaser may avail loan for purchase of the property and shall arrange for entire sale consideration due under clause 2 by bank loans on receipt of the entire sale consideration and disburse a letter from so and so and so. The vendor shall execute and register a valid sale deed after receiving the entire sale consideration and hand over schedule 2 property to the purchaser duly completed in all respects.
Yes.
And my submission before this court is, Milord, the performance on the part of the respondent is delayed. My disputes, as of now, which has been referred to the arbitrator, are the construction activity which has been made out by the respondent number 1 under the development agreement. Because he is being a developer, he being owner of the property, there is no development agreement as such.
Yes. Yes.
That has been not complied. There is a express damages clause made out in page number 62, point number D1.
Yes.
Page 61, point number D1.
No, that is altogether different. No, that is not required.
This is out of record. So my humble submission to this court is, Milord, because by virtue of the letter of intent being made part and parcel of the agreement of sale,
yes,
the parties are bound by the arbitration clause of the
yes
agreement between the parties.
Yes.
My first submission.
Yes.
But the second submission which I am submitting, Milord, with respect to the stamp duty, Milord, because the matter is being now referred to a larger bench by the Honorable Apex Court. But then that judgment is as of now, Milord, pending. But this the judgment, if this court comes to a conclusion that is bound by the arbitration clause, the judgment of this court has to be deferred until the orders of the pronounced by the Honorable Apex Court. Milord. That apart, my other submission is, Milord, the taking of this deficit stamp duty, Milord, ipso facto, cannot take away the right of the parties, Milord, on the original side. document, this document is a curable defect, and defect can be cured by the even by the honorable London arbitrator appointed by this honorable court. The adjudication process is still continuing. Under section 11, my lord, I am rely upon Supreme Court judgment, my lord, wherein except for looking whether the parties under express consent are given the consent for the arbitration, whether the parties have given their whether there is an agreement between the parties and arbitration clause, nothing has to be looked into by the honorable court under section 11.
Yes.
Some of my argument was saying that the upon arbitration application may be allowed, or that it may be deferred until the orders of the honorable apex court. Yeah. Some of my.
Yes. Yes, madam. Yes. 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 Page number 22. Yes. Yes. Yes.
No reference to the element of fine. That financial method, I think was then global judgment and subsequent repercussion.
Yes. 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 Yes.
The absence of such period. The agreement of sale cannot be. With a letter of intent.
Yes.
The letter of intent itself clearly states, my lord.
Yes. Yes. Yes.
This letter of intent.
Page number
46, man.
46. Yes.
This letter of intent shall constitute an open offer until 31st January 2000, which time it shall be not exceeded by the secretary.
Yes.
In the date of
Yes. Valid only up to 31st January. Yes.
3 months in the next paragraph.
Yes.
Seller understands the purpose of this letter of intent.
Yes. 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 Yes.
Without further investigation by both parties.
Yes.
This letter of intent is parties to the contract negotiation. If the purchase
Yes.
itself shows it's not completed contract. On basis of which it moves to arbitration.
Yes.
I think translation of cancellation of the contract. One of the applicant here.
Page number, cancellation of the, where is that?
Page number 44, my mistake.
Yes.
Each party, they have entered into together, meaning that it's one composite piece of property that they wanted to purchase together, not pieces, bits and pieces here and there.
Yes.
It's a composite piece of property that they were supposed to purchase.
Yes.
Where the obligation was on the respondent after receiving the other clause, the obligation to register only after receiving the entire sale consideration.
1 minute.
Admittedly,
Class number?
clause number 4, my lord.
Yes. The following.
Percentages of what is there, that is there in internal understanding. My lord.
Yes.
Concerned with how much each person shares.
Yes.
With all of them. Page number 29, purchasers. 12 purchasers are paid.
Yes.
All of them. An extent of land, my lord. Sorry, an extent of constructed commercial space.
Yes.
There's a partial cancellation, and admittedly, my lord, the registration is to be done after receiving the entire sale cancellation.
Yes.
Admittedly, my lord, out of the sale cancellation of about 17 crores, my lord, 11.2 crores is only.
And that may be recorded.
11 point?
2 crores. It's admitted.
Yes. Yes.
My lord, that is because they've said that meager amount is remaining, my lord.
Yes.
Sorry, from my perspective, 7 crores.
Yes. Yes.
My obligation to register to all of them together, a total extent of land, is unenforceable, my lord, where some small part or whichever extent of portion.
Yes.
It is now really not possible for me to register the remaining to the sellers. So when they're joined in like
Yes.
next one. In fact, the document which was given to me, I could not see the second part of the registered portion. The application. Because it's a company, my lord, it's kind of
Now the
assume that the company had taken because it was filing proof and the court had accepted.
Yes.
No such person can't be treated as a valid notice method under section 11 of the Constitution, which is a mandatory clause under section 11.
Now the notice sent to the very same address, the address mentioned in the agreement of sale and intent of letter.
Yes.
Now the particular office also situated as on the date of issuance of the notice in the very same premises.
I don't know why it says, but notice admittedly by the fact that the file is written copies saying no such person.
No.
That
No.
addressee absent.
Now the what is the law says? Now the suppose the address notice sent to the correct address, last known address. Then
My lord, note served to the last known address, my lord, not sufficient, my lord. Unless it can be shown that there was a deliberate attempt on behalf of the respondent, my lord, to not receive the notice. My lord, in bona fides, I'm saying here, my lord, no such attempt was made. Because it was not no such notice was given till the arguments today, my lord, because the cover.
no, that's why it's not filed. Why? No, this is nothing. This is the original side proceeding.
I already, I don't know why it is being not from there. I hold the copy of it. I hold the copy of it.
Yes. Yes.
No.
Yes. Yes. This is yes.
For the section 11 notice reaching the mandatory, my lord.
Yes.
for appointment of
No,
arbitration. The application itself now.
neither the part is not pleaded in the counter affidavit.
We were not able to ascertain those.
No, only during the course of time, this court pointed out what is that endorsement.
In answer,
Not have.
Now this very
Milord, I may.
only you are the now you are the
I understood, Milord. There are 3 notices altogether.
no this no this is nothing but in the original side proceedings.
Yes, yes, no. I totally agree.
It is in a summary proceedings, but this court is having a
Yes, yes, no.
has to
Not here in this case, 2 notices have become as no such person, but the 3rd notice came as addressee absent.
no such person. This is a firm. This is a company. This is
Milord,
company.
first one is S. Sridhar Rao. Milord, the address made out in the first envelope, Milord, is the same address shown in the arbitration application. It has given our impression as
Yes, madam. Yes, please. Okay.
Since I do not know about that.
No, once again, matter has to be adjourned. One reason or other reason. That is in a very now the
I'll solve it.
even I will be permitted to not even I may rely upon chloro controls judgment, Milord.
yes.
But I may rely upon
1 minute. Yes.
Where subsequent or some agreements, my lord, some
Yes.
not party.
In that very judgment, there is a reference where in law.
This please, madam, come. Now the question of yes.
But I permit to answer 2 few issues.
Now the argument is not completed.
Okay.
The submission is completed. Yes.
Let's see the applications. Section 11 application. The arbitration clause, valid arbitration.
Yes.
Valid dispute also I am disputing my dispute as such because without performing their end of the contract of
Yes.
it's not
Yes.
the fact that the statutory notice is not the circumstance application section 11.6 is not maintainable. Statutory notice is served as per the
Yes.
liability matter. The global controls doctrine cannot be the fact that the prayer itself does not refer for 2 reasons. One is that the doctrine laid down in global controls is related to group of companies members.
Yes.
The scope of that judgment can't be expanded to saying that multiple agreements between the parties and between all those agreements it has to be the same.
Yes.
Put in or can be referring to all those agreements.
Yes.
Another agreement between parties for purchase of some other property, they can't rely on same agreement saying that same companies or same parties, so therefore the arbitration.
Yes.
My lord, to the extent of the first thing, my lord, in their application itself, they are not, the prayer itself, they are not relying on the agreement of sale. Second thing, in case they are relying on the agreement of sale, my lord, stand. So, my lord, I think it should be.
Yes.
The present, we are bound by the present.
Yes.
I may say to Lord, the as likely addressed by my learned friend, my lord, the judgment relied, my lord, of the Honorable Apex Court made out in chloro controls speaks, suppose, my lord, wherein multiple agreements are entered between the parties. One such agreement, my lord, there is an arbitration clause. The Supreme Court laid out a law saying that, my lord, that arbitration clause, my lord, all it's applicable to all the agreement interested between the parties.
Yes.
That judgment I may rely upon. The other aspect, my lord, with regard to the notices, etc., Lord, there is no abbreviation as of now, Lord, made out even in Lord. Even this has to be even examined because 3 such notices have been sent. Lord, the notice sent to the respond number 1 has come as no such person in this plot. The second notice has claimed as unclaimed written to sender. Lord, my lordship, if you see, kindly see my cost title for a moment. Respond number 1, I have made out 2 addresses.
Yes.
One address, my lordship, is referred as plot number 52, road number 10C, MLA and MP colony, Jubilee Hills, Hyderabad. The other address which I have said, my lord, that is survey number 86, 87, 90, 91, Sandhya Techno 1, opposite Sunshine Hospital, Raidurga Main Road. My lordship, kindly see, my lord, this has come as unclaimed return. Okay, sir.
Yes, yes, you file memo along with you by duly serving upon it. Yes.
Yes, ma'am. I'll file this, ma'am. So, my lord, as made out by my learned friend, but the agreement of sale, my lord, is executed by the respond number 1. So, one such notice is written as unclaimed, but that shows sufficient proof of service on the respond number 1.
Yes.
My lord, if my lords may kindly see section 21 of the Arbitration Act.
Yes.
Section 21 of the Arbitration Act, my lord, it reads about Section 20 of the deals with commencement of arbitration. The section provides that arbitration proceedings commence from the date the request to refer the dispute to arbitration has been received by the respondent unless the parties themselves have agreed upon a particular date.
Yes.
Received by the respondent. Here is case. But deemed the service there under General Clause Act, my lordship may know that. I may harp upon the deeming clause made out in General Clause Act.
Yes.
But by virtue of this notice came as unclaimed, it has to be served as deemed notice. The other aspect, my lord, I may sum up my argument saying that by virtue of execution of cancellation deed, during the pendency of arbitration application, it goes impliedly saying that all the applicants 1 to 12 are signatories to the agreement of sale and as well as letter of intent. So it has been signed by one person. My submission. Because my lordship has put it, my lord. Cancellation of agreement, but under the agreement, even the signatory of the cancellation agreement is not a signatory. Lordship understood. But it goes to show the implication saying that, my lord. The agreement, my lord, has to be deemed as signed by all the parties.
Yes.
My first submission. The other submission, my lord, I made it clear that substantial amounts have been paid. But now the quantum of the amount and, my lord, the damages or the application of the, my lord, the liquidated damages clause under the agreement. But it is the subject matter of the arbitrator to be looked into by the, before the arbitrator.
Yes.
I sum up my argument saying that, my lord, let an arbitrator be appointed, my lord, for adjudication of the dispute interested between the parties.
Yes.
If in case this court comes to a conclusion that the agreement of sale has to be registered, we are the applicants here and are ready to execute ready to pay deficient stamp duty, that be a curable defect. That may not ipso facto take away my right, my lord, for the maintainability of the arbitration application.
Yes. Now this court can record your submission that you are ready to pay deficit stamp duty.
Yes, my lord. Well, that is a law, I cannot deny that aspect.
You said that by virtue of the larger bench, the matter referred to the larger bench.
As of now, it is not there.
Taking dual stand. That is which stand?
But I myself, my lordship, please to see, because until the 5-judge bench judgment has been referred to a 7-judge bench.
Yes.
The matter has been heard and it has been resolved.
Yes.
In the inception itself, I have addressed this court, may not let the matter be deferred until the judgment of the Honorable Apex Court is made out under on the very same subject.
Yes.
And that my other submission is that may not be a sole ground for dismissing the arbitration application. My humble submission is because admittedly there are n number of payments made out by the applicants here to the respondents.
Yes. Then.
Much obliged.
Yes. That yes.
Let's point out, my lord, in the could see. Page number 54.
Yes.
These names are noted, my lord.
Yes.
Represented by Ms. Nagaratna Bosman. Below party number person. Page number 54.
54. Yes.
Presented by Ms. Nagaratna Bosman.
1 minute.
Just below the party's name.
Party's name. Where is the vendor obsolete to possess?
Page 54.
Yes.
Mr. T.R. Venkatesh Miller.
T.R. Venkatesh. Yes.
Represented.
Yes. Represented by Nagar. Yes.
Nagarratna Hosman.
Yes.
See the signatures there. Document. On all other pages, the signatures are not there. Page number 64, purchasers, one signature is.
Who is that signature pertain to whom?
It says, I'm informed, my lord, it's Srinivas Hosmane.
Srinivas. Now the represented by Nagaratna in respect of all the persons.
That's what it's saying.
Where
11, 12.
11, 12.
12, my lord, presented by Ms. Nagaratna. It doesn't say all parties, my lord.
Oh, yes. Whether it applies to the only TR Venkatesh or applies to all.
It's not clear. Document is very vague.
Yes. Yes. Yes.
There's no authorization on behalf of Mr. Srinivas Hosmane to have executed, my lord.
Yes.
This document on behalf of all the purchasers. Because, my lord, the chloro controls was also brought up. In chloro controls only, it was specifically said, my lord, though it's not, the facts are not applicable to this case for regard to the group company's doctrine.
Yes.
Chloro controls following Bogara Polycarb, my lord, has specifically stated that it is incumbent upon the Honorable High Court, while looking into Section 11 applications, to see whether the agreement is valid, operative,
Yes.
and capable of performance.
So according to the signature pertain to whom?
This is Srinivas Hosmane.
Srinivas. Yes.
Following Bogara Polycarb judgment, my lord, chloro controls also again it was reiterated
Yes.
that it is incumbent on the Honorable High Courts when looking into Section 11 applications, by deciding Section 11 applications, to look into whether the agreement is valid, operative,
Yes.
and capable of performance.
Yes. Yes. Yes.
So that is now repeatedly also in the last couple of months there have been several judgments of the Honorable Supreme Court regarding that.
Yes. Yes.
So, my lord, in view of these defects in these documents, my lord,
Yes.
they are incapable of being performed by the respondent.
Yes.
Neither are they valid at the present moment.
Yes.
God bless you.
I made a mention saying that because only the Xerox copy has been made out, no. I will file the originals which I am holding as of now by way of memo.
Not originals, not required. That is an endorsement made in the second.
Endorsement is already there in the court.
No, that is not available.
I will file, kindly permit me to file memo.
Yes, that is normal. Yes. That is only for the purpose of limited purpose. That is. You want to add anything?
If it is so that
Now this one of the notices says unclaimed. As per the unclaimed postal endorsement, as per the general clauses act, deemed service. Deemed service.
on one side it says addressee not found, on the other side.
Now once again we have to put. Now this is very difficult. That is after spend more
than.
We got to report that this memo may also be filed, my lord, for the purpose of the post perusal also.
Yes, the land council appearing on behalf of the applicant.
Any date is given or not, Arjun? For
Reserve. Now you want to place on the judge.
Citations may not even I want to place. I in due course of time, I'll serve the judgment of controls of the
What the learned counsel for the parties wants to place on the, now we will post the matter for, this is not in a good for the arguments, sorry. Yes, ma'am.
Yes,
Heard the arguments of the learned counsel for the applicant as well as the rest. First endorsement PCCN, you file, that is not required, please. No judicial order is required for filing memo. You
Yes,
file, that's.
Yes, much of.
Yes, only simply. Yes, CAB label, post for orders on 16/11, yes. Madam, yes, after long time, yes.
Number 68, the government wants their review petition to be tagged with my contempt application.
Review petition.
They move the review.
Review filed by whom? In which?
Review
petition in
agriculture.
Review petition in this contempt case for non-implementation of the orders passed by.
The petition was closed, Your Lordship. Subsequently, they moved the review. Only when I moved the contempt, the review, now they are seeking.
No, this court is not having a power to hear the review petition. That you have to make a request before the registry. They will place the matter before the Honorable Chief Justice. The Honorable Chief Justice will take appropriate decision on administrative side.
Then let my contempt be heard.
No, that is not a ground. Now, filing of review petition, not listing of the review petition, that is an altogether different. That is in it. You have to take steps. Now, what do you want? Please, we'll give one opportunity. You have to work out your remedies. Not, this court is not having a power to pass judicial order clubbing your review petition. This name. The 68 assistant government period appearing on behalf of the respondent seeks 2 weeks time at her request post on 24th. Okay. Yes.
With your kind permission, my lords, item number 104 to 106, my lords, may kindly post after 1 week, my lords.
114 to
104 to 106, my lords. I've informed the other side, my lords. I'm for the petitioners. 104 to 106, my lords.
06. Are you informed?
Yes, my lords. Respondents counsel is here, my lords.
1 minute on. Item 104 is
104 to 106, my lords. 3 of them connected matters.
we are representing.
Petitioners.
Yes. Are you informed to the?
Yes, my lords. Inform the respondents.
Which date you want?
After 1 week, my lords, any date as per convenience.
105, 106 at the request of the land council for the petitioner post on 21st.
Much obliged, my lords.
Your Lordship.
1 minute, but please, just after completion of the physical, yes.
102. Request for a week. People couldn't trace the button, my lords.
Collect from the court 2016 order, nothing survives.
See the.
Nothing, sir. 102 at the request, madam, at the request of the land council for the petitioner post on 16/11/2023. Finally, no further adjournment. Yes.
Your Lordship, item number 66. The petitioner passed away. We have to file a legal petition, but we did not receive a death certificate yet, Your Lordship.
Contempt case filing LR petition, not this court is having an option. No LR petition required. If any further adjudication is required, the London Standing Council says they already addressed the letter to pay 1,20,000. 1,40,000 for replantation of the trees in other place from translocation.
We are waiting for the death certificate, Your Lordship,
Question of
from the municipality.
adjudication of the matter on merits does not arise. They implemented the orders passed by this court.
Otherwise, Your Lordship, kindly pass over.
Pass over.
Item 7,
Much
contempt case. They filed counter. It may be closed.
Close it up. You are representing?
I am for petitioner.
Petitioner.
Yes.
CC 2412 of 2023. Petitioner. What is your good name? You are
For private petitioner.
Yes. When the matter is taken up for hearing, the London Council, Bala Mallesh D. fairly submits that the respondents implemented the orders passed by this court dated 27/9/2022 and no further adjudication is required. Recording the above said submission, the contempt case is closed. Yes.
Item 90, my lord.
Your lordships, item number
Yes.
6.
Yes, madam. Item
Item
one.
number 67, your lordships. I'm
67.
representing for Chandraya Shankar, your lordship. He is requested for 1 week time, your lordship, for filing reply,
What
your
is a
lordship.
forest?
Item number 67, your lordship.
Yes, 1 minute. Item 67, at the request of the Land Council for the petitioner, post on 30/11/2023. Yes.
Item 90, my lord.
Item 90.
Yes.
90, yes.
Notices issued, my lord, but it did not receive the acknowledgement, my lord. Kindly give some time, my lord.
Sometime after elections.
Yes, my lord.
Yes, item 90, at the request of the Land Council for the petitioner, post on 11/12/2023. Yes.
Oblige.
Yes.
Unless item 73, kindly it may be taken after the next week, Malas.
Item number?
73.
73. 1 minute. 73, yes. At request of the Land Council for the petitioner. Are you informed to Ravinder Reddy? Any urgency?
No, Malas. They filed it.
Yes, yes. Item 73, at the request of the Land Council for the petitioner, post on 21st. Yes. Yes.
Item 69 also, my lord.
69.
Yes, my lord. I am for respond number 5, my lord. I want to file counter in the first time it is coming up, my lord. I filed wakalat.
What is the 2016 order?
16, yes, there is nothing remains, my lord, but anyhow, my lord, I want to file the counter.
Just we'll see what the Acharya
yes.
are going to say.
Yes.
Whether
Yes.
the contempt case is within the period of limitation or not.
No, no.
Yes,
It is
yes.
not.
Well within,
Acharya garu ikkade unnaru. Yes. Now,
well
you say?
well
Yes.
within limitation, my lord, because
Listen, again is the entry order or final order?
interim order, my lord.
Yes, entry order. Yes, yes. How much time required, Ashok Gaur?
My lord, I want to produce some documents, my lord, because the
Yes,
after
yes.
there is an order, my lord, conditional
1
order.
minute, 1 minute. At the request of the Land Council, appearing on behalf of the respondent file, post on 7/12/2023.
Yes, ma'am.
Yes.
7 or 10, whatever.
7, no? Yes, 7. Yes.
Oblige.
Commissioner retired means the other commissioner. Now the division bench judgment party name is not required. The officer is important. We'll see after lunch in the presence of the Land Council for the petitioner. This court is going to grant it. Yes. Silent. Yes. Yes, Anurag. What is the nature of work?
Road laying minute. Lakshmi, two plants are available with the petitioner company. He submitted an application, both the
1 minute. Yes. Why you are not awarded the work? The inspector, there is no interim order. No, in tender matters, tender matters, in contract matters. Now, mere pendency of the writ petition in the absence of any interim order, you are want to keep the, yes, you want to file counter? Yes, Sri Anurag, land count. Yes, we are having
I have not received the minute counter copy from the official.
counter affidavit filed in the month of June 23, June 2022. Your office signature is available in the counter copy. Now you are saying counter copy is not available.
I will take out minute from the.
Please inform to your office concerned, collect the counter copy. Land Council appearing on behalf of the petitioner seeks short adjournment. Now already rejected. One minute. Now he says he is handicapped with the counter affidavit. He is not having your counter. Just will give. No. Yes. Land Council for the petitioner seeks short adjournment. That is request post on. Which date?
2 weeks, Your Lordship. In the meanwhile,
No, 2 weeks. 16th or 17th. Choose any day. 18th also working day. This next week 18th short day also working day. Yes.
Your Lordship, 18th, put it to 18th minute, Your Lordship.
Why 18th? 16th.
Lordship, I will take out
17th. Post on 17th. Yes. And by apologies. Yes. 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 Morning, yeah, at your request only passed over. What is it? Yes, at request of the land council for the petitioner. Post. Yes. Yes. What is the issue? Yes, when the matter is taken up for hearing on 3/11/2023, no representation on behalf of the petitioner as well as the respondents. Sorry, the respondents say no representation on behalf of petitioner to give an opportunity posted to 10/11/2023. Yes.
Item 60. Here I will keep it for
Mayor Parthasarathi retired as a principal secretary government. Contempt lies against the concerned officer who is discharging present. Now this court is issued direction to consider the representation by the principal secretary, not by C. Parthasarathi. Now, this court is going to admit the contempt case against the principal secretary, present principal secretary. He will get 4 weeks time. Now they please see the division bench judgment in one case says person name is not required in contempt petition. 1985 3 APLJ 68. In contempt petition, court can be punished no necessary to impede the particular officer as a party respondent. Any other judgment contrary to this judgment will give final opportunity. Land assistant government pleader appearing on behalf. $120. Yes. Yes.
item 60.
Yes. ప్రభాకర్ కొట్టేసిన తర్వాత వస్తాడు మళ్ళీ నాలెడ్జ్ అంటారు. Yes. Yes, what happened? This is complaint. Complaint. Yes. No representation on behalf of Pradeep. T. Pradeep. Contempt case is closed. పైన ప్రభాకర్ రావు గారిదేమో నో రిప్రజెంటేషన్ అని yes.
Item 66. Ayamura, Equipment Forest.
Yes. $88,000. No, what is it? One minute, one. Yes. Now, under the Land and Trees Act, whether municipal authority is having a power to remove the tree under the particular environmental laws or the Land and Trees Act, whether the municipal authority is having a right to remove the tree. No. Only relocation, replantation. Now, who has to bear this expenditure? Yes, now they are not third party. No, yes. Now they want to widening the roads in national highways. They are all now the government and government authorities are engaging the service of the private contractors only. They are not having any men and machinery. They are not having any expertization. Suppose you whether any person, technical person is available for your site within with a low expenditure, you furnish the said particulars, we will direct the municipal authorities to yes, yes. Now with your expenditure. Now yes, yes. No, you give small amount even without paying any amount, you remove and relocate as per the instruction. Allow. You take responsibility. Now, without paying any amount to the contractor, the expertization. No, no. This quote is only considered on that day when you are present. When if you are ready to pay that expenditure, this quote is dispose of the matter at the stage of admission. In a consent order, we give one opportunity. Now this says then the petitioner is no more. Yes, land council. What is your good name? So and so land council representing Mayur Munda submits that the sole petitioner died and seeks 2 weeks time to bring the LRs and proceed with the contempt. At her request, seeks 3 weeks time for filing, taking necessary steps and to proceed with the matter. At her request, post on 15/12/2023. Yes. 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 Item 70. Yes, Yadagiri.
Millard.
Now the land standing council says orders implemented.
No, Millard. Millard, after filing of contempt petition, they submitted all these things, Millard. Before that, I issued the notice. They received the notice. They will.
No, just 1 minute. 1 minute, Yadagiri garu. What is the order passed by this court? What is the violation? What is the violation?
At the time of filing of representation, they stated that the mother of the petitioner is a serpent. She misappropriated the amount due to that reason only. Can you see the para 5 of the counter, Millard?
Now, please read page number 10, operative portion of the order. Please read, or I will read for your benefit.
Yes, Millard. Dispose of the representation of 11/11/2022.
Yes. Pursuant to the orders passed by the other learned judge of this court, whether the fourth respondent consider the representation passed any order or not.
No, Millard. We are not received any order copy after filing.
1 minute.
Yes, Millard.
You are not having copy of the counter affidavit filed by the.
Today morning, I received the copy, Millard.
Yes, along with counter, they enclosed the copy of the proceedings dated 31/1/2023.
But they are not served on to me. Without serving the proceeding after filing of this contempt petition only, they served they filed this proceeding along with the counter copy, Millard.
Now what follows?
They simply stated that the resolutions are forged one and the
yes,
forged one.
Now this court is not given any other directions. This only direction given by this court directed the fourth respondent to consider and pass. Now they passed the particular order.
Suppressing the facts that, Millard.
Now this scope, 1 minute. Scope of contempt. Whether this court is having a power to decide validity of the orders passed by the Mandal Panchayat officer in this contempt case.
They have minimum responsibility to serve the copy of the proceedings.
Yes,
they are not served. After filing of the counter only, after filing of the contempt petition only, they file the proceedings.
Yes. We'll grant liberty. Yes. CC 2373 of 2023. Petitioner filed this contempt case to punish the respondent for non-implementation of the orders, non-compliance of the orders passed by this court dated 23/12/2022 in WP 45790 of 2022, invoking the provisions of Section 10 to 12 of the Contempt of Courts Act 1971. Heard Sri Cherukuri Yadagiri, learned counsel for the petitioner, and Sri R. Chandrasekhar Reddy, learned standing counsel, appearing on behalf of the respondent. Full stop. The sole respondent filed counter wherein stated that pursuant to the orders passed by this court, he considered the representation submitted by the petitioner and issued proceedings by number A4/10/2023 dated 31/1/2023. Copy of the said order is enclosed along with the counter affidavit. Learned counsel for the petitioner submits that the respondents not communicated the said order to the petitioner whom he enclosed the copy of this order along with the counter affidavit to avoid the contempt proceedings. First off, having considered the rival submissions made by the respective parties and after perusal of the order passed by this court dated 23rd December 2022, wherein this court disposed of the petition directing the respond number 4 to consider the representation dated 11/11/2022 and pass appropriate orders in accordance with law within a period of 4 weeks from the date of receipt of copy of this order. 24. Yes. Pursuant to this said order, the respondent consider the representation and consider the representation submitted by the petitioner dated 11/11/2022 and passed the order by proceedings number so and so dated 31/1/2023. Full stop. In view of the same, the cause in the contempt, no further adjudication is required in the contempt case. In view of the complaints of the orders, no further adjudication is required. Accordingly, contempt case is closed. However, the petitioner is granted liberty to avail the remedies as available under law, questioning the order passed by the respondent dated 31/1/2023. If so, is advised by raising all the grounds which are available in law. Yes. Accordingly, contempt case is closed. Yes.
Deeply.
Yes. Yes.
I have 72. Pocket, that still supplies.
1 week you want adjournment? Why? Yes. What is the issue? Counter also filed. No counter. Even notice is ordered. We'll order notice before admission. Learned government paid civil supplies takes notice on behalf of respond number 1. Yes. Yes. Yes.
I have 72.
73 AP Reddy full lunch. He says he informed to you. He seeks adjournment. AP, you are having any urgency? Oh, basing on your court slip only the matter listed. He says yes. Court ఎప్పటికి ఇచ్చాడు? Yes. Date file ఉందా అయిపోయింది. 21st just be. Now he says informed. That's why. Yes. Yesterday I have during the course of reading your court slip is available. ఒకసారి కోర్ట్ ఆఫీసర్ ఉంటే అది 16th వేయండి. Yes. Please inform to AP Reddy advance to 21st to 16th. Better. Yes. Yes. Pilvaling, just please wait. The matter is not call. Yes, yes. What do you want? No, after lunch, 3 o'clock, Passover. Yes. Post on 1611. Yes. Yes. Your proof of service not available. Meantime, you proof of Muzib, proof of service, just pursue in respect of unofficial respondent 678. Yes. We are representing. Yes. 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 Which writ petition you want to? 42516. Yes. Now we 2015 writ petition, 2016, 4 plus 3, 7 years. 1 minute. Revenue file vacate stay petition. No, the vacate petition is counter affidavit available. Yes. Yes, agriculture market committee also file. Now you will take care. Agricultural standing council is here. Now you are supporting the petitioner. Now you are the beneficiary. Now you are the beneficiary. Now you have to take responsibility. Now this is you are requisition authority. They are only acquired and allotted. Suppose the revenue proceedings is going to be set aside. Now who is the loser? Now you have to take responsibility. Ultimately, in any case, only beneficiary has to take more responsibility. Yes. Now you want to rely upon the government stand. That is ultimately you have to. No. Yes, you have to take responsibility on behalf of the government also, because you are the beneficiary. Suppose any illegalities, for whether if committed, you have to. Yes. Normally, APASC, land acquisition, anyway, beneficiaries, they have to take responsibility. Now the property is in your position. Suppose the land acquisition proceedings is going to be initiated, suppose by virtue of the relief sought by the petitioner, you have to pay the compensation. Yes.
Whatever.
Now, what do you want? You are ready or not?
Yes, because of this only I came here. Last time the matter will not be adjourned further. No, soon.
First we'll hear Lund.
Yes, I will be my.
Last occasion when Lund Senior argued the matter, this court requested. Yes. First yes.
I will narrate the facts, few facts that will suffice the issue.
Now 42516.
42516.
One. Yes.
The petitions are 4 in number. They are absolute one. They purchase the plots 102, 92, 109, and 100.
Yes.
In survey number 196 by AA.
Yes.
Double A millets.
Yes.
That's the more important. That's of Shankarpalli village. Total extent of land in survey number 196.
Yes.
Is 9 acres 28 guntas.
9 acres?
28 guntas.
Yes.
As per the revenue records as well as the
survey number?
196 millard.
196, yes.
As per the revenue records and also Kasra millard 54. Out of the total extent of land, 6 acres 28 cents was sold to local body.
Yes.
On payment of consideration, by the registered document
way back in 1945.
Yes.
By the original owners, Millers.
Yes.
That is Sankaraya and Ramulu.
Yes.
Survey number 196 was subdivided.
Yes.
As 196 by A and 196 by AA. That is 196 by A consisting of 6 acres, 28 guntas.
Yes.
196 by AA is of measuring 3 acres.
Yeah.
Since the land in 6 acres, 28 guntas was sold, the remaining land of 3 acres is there in 196 by AA.
Yes.
Which is in question marks. The out of total extent of 6 acres 28 guntas in 196 by A.
Yes.
An extent of 3 acres 20 guntas was gifted to Agriculture Market Committee.
3 acres?
3 acres 20 guntas.
Yes.
By way of a gift deed dated 27/5/1976 by the Gram Panchayat.
Yes.
The remaining 3 acres 8 guntas is with the original owners.
No, first instance you say
6
acre 28 guntas.
In 196 by A.
196 by A.
Yes, sir. That is the remaining extent of land of 3 acres 8 with the Gram Panchayat. 6 out of 6 acres 28 guntas.
Yes.
3 acres 8 guntas. Let's got it. Out of 6 acres 28 guntas.
Yes.
3 acres 20 guntas was gifted to AMC to Agriculture Market Committee by the Gram Panchayat.
Yes. Yes.
The remaining extent is with the Gram Panchayat. 3 acres 8 cents.
Yes.
8 guntas.
Yes.
In respect of the reparation is concerned, the property was purchased by these petitioners and along with some others under various sale deeds. I filed Miller's sale deeds also,
yes,
which are material papers from page 62.
Now the subject matter confining to the extent of land?
3 acres, Miller. 3 acres in 196 by AA.
3 acres?
3 acres then.
Only 3 acres, yeah. Yes. The remaining 3 acres.
3 acres, we are not, I am not concerned with the 196 by A.
Yes.
I am concerned only 196 by AA.
Yes.
I purchased the property under various registered sale deeds and the layout was drawn. The plots were purchased by the petitioners.
Yes.
The suddenly, because the 196 by A was a dispute dispute between the revenue people as well as the persons who are in occupation of the property.
Yes.
Then they purchased, they constructed the buildings.
In your land?
No. 196 by A.
196 by A.
Yeah, I am 196 by AA. I am concerned only.
Yes.
Then they, by virtue of the GO issued by this by the government, they filed an application for regulation of the respective plots.
Yes.
Then the MRO recommended their applications for regulation. That your lordship may get it at page 45.
45.
That is dated 15/9/2015.
Yes.
Second parameters. Lordship.
Yes.
For regulation 196, for subject matter is 196 by A. Lordship got it, no?
Yes.
Top. In this regard, on 11/9/2015, I along with VRO so and so, and inquired the matter locally. In the inquiry, it reveals there are about 55 houses in which people are staying. Houses are halted by laid roof, houses in semi-finished, so and so. The entire land is covered with the boundary wall, where their structures are situated 196 by A and 197 of Sankarpalli village, Mandal.
This is in a report submitted by the Tahsildar.
Tahsildar.
Yes.
For regulation under GMS number 59.
Regulation in respect of extent of land?
the small pieces of land, my lord, were occupied by the persons. That you'll actually by page 58, my lord. Page 58, penultimate para is. Yes. Penultimate parameters. Now we received 66 applications in 196 and so on, so on, GMR 59 issued revenue department for regulation of houses. All these applications were inquired, but scrutiny is under process. At present, no construction activities are going on. That's all. Now the report says there are about 55 houses and semi-constructed houses and people are residing there. Yes. Ignoring this, because the 196 by AA, in which we are we purchased property, they thought of changing the topography of the same, showing that my land is situated as if my land is situated in 196 by A, but not in 196 by AA. Yes. That suddenly they because my land is under vacant sites, that your lordship may kindly see, then the impugned proceedings issued, to whom your lordship may kindly see. Page 21 starts. Show cause notice. Yes. Page 21. Office of the Tahsildar to EO Shankarpalli village. Your lordship may kindly. Yes. 6/10/2015. Yes. What they say, subject matter, let's say, occupied, then your lordship may kindly see para 3 millers. Yes. At present, out of 6 acres, 28 guntas, 3 acres, 20 guntas, he is having with the market yard and balanced to land to an extent of 3 acres, 8 guntas, is encroached by one Subbaraja and made plots and started constructions. What he says, he gives notice to the EO Shankarpalli village. Yes. He himself says that that was occupied by the second para. Just sorry, Millard, I misread, Millard. Through the reference 7 site, it came to the conclusion that the bearing numbers 196 by A, an extent of 6 acres 28 guntas is originally patta land and acquired by the then district board so and so and hand out to the Shankarpalli Gram Panchayat for the what the 196 by A is concerned 3 acres 8 guntas. The lordship may kindly see. 3 acres guntas. Into the Grama Panchayat. Yes, Millard. That's 196 by A is not my concern. Yes. What they say is 196, as if they issued a show cause notice to the Gram Panchayat, as if 196 by A is a vacant land. Yes. Then the even though some of the one of the third para indicates that some of the encroachers are there in the property in 196 by A also. Yes. Page 22, Millers. Then. Yes. This is a resumption proceedings. Yes, Millard. The show cause notice issued to whom? Executive officer, Shankarpalli village. Lordship got it. Not to the petitioners. Yes. What they say is, the lordship may kindly see page 22. 22, yes. Now the second para last sentence. Now the remaining area of 3 acres 8 guntas, which is being encroaching unauthorized by the illegal persons, started construction activities and the same are stopped at the pillar level. He himself says issued under which act? I don't know, Millard. That's the question posed by the other learned judge. Resumption proceeding, resumption order issued in under which enactment? No. Now the page 22. Though the show cause notice issued reference 8 cited, but no reply was. That's a he issued a notice to the Gram Panchayat. Lordship may kindly see. Yes. He says that some encroachers are there in 196 by A. Yes. Now then the memo. Yes. Everything is done in a office room, Millard, subsequent to the proceedings issued by 10, 14, 10, 511. Yes. By this office to the Mandal Revenue Inspectors and so with a direction to resume the subject land of 196 by A, 2 acres 38 guntas, and a meeting held in the chambers of the district collector as mentioned in the reference 10 side of the Mandal Revenue Officer, Mandal Surveyor, Village Officer, Shankarpalli are hereby directed to resume the subject land 196 by A The extent of 2 acres, 38 guntas inside the compound wall of the Richik, so and so, so and so.
Now the subject land, 3 acres, 8 guntas, which are under the subject property out of 6 acres, 28 guntas.
Yes.
Whether the particular Gram Panchayat land is available?
Now that was occupied by so many people. That's it.
Now under the guise of these proceedings, they are trying to
dispose the petitioner. Your lordship may say, your lordship may kindly see the mediator's report.
Yes.
Yes, I will show how they morphed the. They did not even survey the land.
Now this land allotted to the marketing committee.
Now
this in a double A. Yes, subdivision. Yes. You are also not disputing that the 3 acres belonging to the private individuals.
Before going further, Vilas, just I wanted to.
Yes.
190.
Yes.
Just I wanted to, because the persons who are in occupation of land in 196 by A approached this honorable court and obtained say.
196.
By that I have filed the order copies of the lordship. May kindly see for a moment.
Oh.
Because they obtained a stay, they can't be evicted. So they thought that this property is a vacant land. That your lordship, page 89 minutes. Page 89.
The petition also filed by your office on that.
196. My contention in that case is that they are under process. This 15 under regulation process. In the meantime, they wanted to dispose that your lordship may page 9.
That petition.
That's our pending lords. Because they have not even filed the count. Page 90 lords, because they are eyeing only against the property which is vacant land. Because they can't take this already. That you are page 90, Millers, page 90.
Yes, 90.
Yes, so
90, 91 also.
All the
petitions are pending.
Prima facie, lords, kindly see page 90, Millers.
Yes.
Yes. Prima facie, it appears that the petitioners have obtained permissions from the Gram Panchayat. They obtained the permission from the Gram Panchayat and constructed houses, and though no separate notices appear to have been issued to them seeking demolition of premises. The status quo.
One more order is available. Page number 97 is very peculiar.
97 and
95 to 97. 3399 of 2015.
And we are not proceeding against the 197. What they say is, it is submitted that the learned standing council market committee that they are not interfering with the land in survey.
No, that is a subject line. This is a subject line.
That's a subject line. What they say is, lordship may kindly see. What they say is 197 is 96 by A is the 196 by A. One way they say, Tahsildar says 196 by A is occupied by so many persons and constructed houses, 55 houses were constructed. And
who is to decide that is an identification of the land?
The survey has to be conducted. Now
when the survey conducted?
No, that's under the mediator's report. Overnight they wanted to take page 29 minutes. It's a mediator's.
Are you filed any application before the?
They have to, because they survey. I am in possession of the property of. They have to. Now the page 26 minutes. Just
revenue authorities, what they stated in their.
Nothing. What they simply silent about the
identification of the land.
They say is this is the land. They can't take a different. But so far as the report of the very same deponent, the lordship has seen the report of the MRO Millers in the year 2015, that is 15/9/2015, your lordship seen that. Where 55 houses were constructed in 196 by A. How can they? Even
according to the report also, some of the unauthorized persons occupied and made constructions.
Because what they say is it's a government land. Why what they say is that's a government land, it's a purchased property from the Nandi builders and we are there in possession of the property.
Now the official respondents are disputing your ownership and title.
No. What they simply say is this property is 196 by AA but not 196 by A, my property. 196 by A is pending subject matter of the writ petitions, so many writ petitions.
The regularization.
That they can't say no, this is 196 by A.
No, page number 45 Tahsildar report also says the survey numbers including 196 AA also is in position of the third parties. Page number 46. Kindly see.
46 and
report starts from 45. 46.
Yes, sir, table and
survey
Kasra.
Survey number, extent, name of the pattedar, name of the enjoyer.
That's the original one. That's 196 by A. Your Lordship may kindly see the name of the pattedar.
Ultimately, one report 196 by AA. What the Tahsildar says in the report?
Report report does not indicate about the 196 by AA. He is only concerned with the 196 by A. That your Lordship may page 58. Ultimately,
the Tahsildar says Tahsildar says the persons are in occupation of encroached, they are in possession of the property. They submitted applications for regularization.
That's 196 by A.
It is not stated 196 by A. Submit 196 and 197.
196 by A and 197. That's your last second page, second para.
Ultimately, last para.
That's a subject matter, Miller. Subject your Lordship, we can see. Lordship. Survey number 196 by extent 3 acres 8 guntas. Encroached by A. Subbaraju, illegal construction taken up.
Yes.
That's a one. 196, what the report says, this was 196 by A was encroached by so many people. 55 houses were constructed, 91 houses are under construction, and it's a fit case to be regularized. Because that
last para is says
197 is also included.
196 and 197.
Yes,
there is no subdivision. Now we received 66 applications in survey number 196 and 197.
And some of the probably 197 people are persons who are in occupation of the 197 also made accurate. Ultimately, 196 by AA, your Lordship may kindly see Kasra. I need not trouble your Lordship, my Lords, 196 AA.
Yes.
That your Lordship may kindly see the second 46 page. And
yes, 46 page.
That's Pattedar's name is reflected. Your Lordship may 3 acres, Narayana was a son of so-and-so, Pamalu. The 196 by A is some Mir Majlis local fund, and the ultimately the 3 acres are in 196 by A is a private property. 196 by A, I am not concerned because that regulation proceedings are there. I filed the writ petition and got the stay. Now the stay, because of the stay there in 196 by A, really changed the topography, and now this is vacant. That's just I will I'll take your Lordship to the page 26 is the
page number 57, 2010, 2011 Kasra Pani. Nari Pahanis. Not Kasra. 57.
Page number,
page number. Very same report, Tahsildar report. 2010, 2011, 196 by AA.
Yes, madam. 196 by AA plots and Mavi.
3 acres.
3 acres.
Vishnu Pantula Srinivas.
That's a Patedar, sir. From whom I purchased the property. Under register sale, your Lordship may kindly see. Your Lordship may kindly see for a moment. Now, because the stay was obtained and the houses were constructed in 196 by A, they want to take the property in 196 by AA of 9.
What is the relief sought in this writ petition?
That has to be the proceedings are to be set aside, Miller.
Which proceedings?
The mediator's nama, Shoka notice memo, because no notice was given to us.
This in a Shoka, this notice is pertaining to 196 by A only.
A only. Under the guise of 196A, 196 by AA, that's just I will demonstrate how they, your lordship, page 26, page 26.
Now the beneficiary says they are not interfering with your position. What more you want?
No. Because by taking that advantage of that fact, they want to take, your lordship, just I need not trouble you, page 26,
Page 26.
mediator Srama. One.
Yes.
Northern is 196 by AA. Your lordship will kindly see for me. Right side top.
Yes.
196 by AA.
Yes.
It should be 196 by A is top, not 196 by A should be below that. That your lordship may layout plan. Then your lordship may kindly see for a moment. 43. Page 43.
Whether the petitioner submitted any explanation to the show cause notice?
మాకు ఇవ్వలేదండి షోకార్ నోటీస్ ఇస్తే మేము అసలు దేర్ ఇస్ నో షోకార్ ఎగ్జిక్యూటివ్ ఆఫీసర్ గ్రామ పంచాయతీ బిట్వీన్ టూ అఫీషియల్స్ straight away they passed the memo that layout and layout.
Yes, what is the stand taken by the counter affidavit filed by?
What they say is,
where is your specific ground raised by the petitioner in your affidavit that the show cause notice issued in respect of 196 by A
yes,
under the guise of this?
that's entire affidavit indicates that. That's I will take the
which one ground is sufficient. Page number 9.
para 10 then.
Para 12. Yes.
10 and 10.
10
9 నుంచి ఉంది. It is submitted that as per the proceeding in para 9 and
page 12 is sufficient. Yes. What they stated in respect of para 12?
what they say is only 196 by A. Contrary to their report. 196 by, they report one way, their report say 196 by A is consisting of so many houses.
What is the next case? Double
plot owners, different plot owners filed different petition.
different plot owners in respect of?
The very 196 by A.
Oh, they are subsequent purchasers.
కాదండి వీళ్ళతో after obtaining this stay, లేదు దీంతో
Now this entire land already converted into non-agriculture, divided into
plots. Now your lordship may kindly see the layout plan.
1 minute. What is the extent of the land of the petitioners 1, 2, 3, 4 in the
Plots number, just I will take. Any plot number 1 or 2 is 200 square yards. Any.
No,
that your lordship may kindly see the sale deeds. I filed.
Now we are claiming in respect of entire total extent of 196 by A.
To the extent of the petitioner. Now the other petitioner.
To the extent of the petitioner, how this court is going to divide that portion?
The other petitions are also there. Writ petitions are there. 2 writ petitions, other writ petitions are. Now the only point is that
the petitioners are having 4 petitioners are having what is the extent of their
200, 200, 800. And
where you are mentioned?
that your lordship first pair.
Oh, 200, 200.
That your lordship may page tablet form.
Page number 9.
How I purchased the property.
Yes.
How just before how they morphed the sale topography, just a layout plan. Layout was approved by them. Yes, I will take your lordship.
Where is that layout? Gram Panchayat layout or?
గ్రామ పంచాయతీ వాళ్ళు
గ్రామ పంచాయతీ లేఅవుట్ లేవు
కాదు ఇప్పుడు గ్రామ పంచాయతీ ఇది కూడా గ్రామ పంచాయతీ మీడియేటర్స్ రిపోర్ట్ కూడా అట్లీస్ట్ దట్ పేజ్ జస్ట్ ఐ విల్ పేజ్ 43 మిల్లర్ పేజ్ 43 ద లేఅవుట్ that is issued by page 12 is the director of country and drone.
Now, is on today whether who is it? The petitioners are in
position. In position of the property. Now the page 43 indicates 196 by your lordship may kindly see above the diagram. 196 by R belongs to the Itkaf Ahmad. Your lordship.
Yes.
That is 196 by A is situated on the northern side of the petitioner's land.
Yes.
Now they changed the topography and the south.
Yes, government feeder. No, what do you say? This in a government feeder revenue comes general revenue. This is with the government feeder Srikanth Reddy. Yes, what do you want to say? PR of 5. Yes. Yes. No. According to the entire 9 acre 28 guntas land is belonging to the government. How we are saying that you are the grabbed? Now you are not disputing the original owner rights. That is who is the original owner?
Vishnu Pantula.
Vishnu Pantula.
That page 46.
46. Yes. Original Patadar Vishnu Pantula. 196 by A, 196 by double R A. Total 9 acres, 28 guntas. So how you are saying that they are the grabbed the property? No. Your own record, revenue record says 1954-55. That is in a Kasta Pani. That is in a crucial document. Kasta Pani clearly says 9 acre 28 guntas belonging to the Vishnu Pantula, who is the Pattada, Enjoyer, Mir, Majlis. All right. Yes, very important matter. Now the respondents not issued the at least notice to the persons who are in possession of the property. The notice is issued by the revenue officials to the Grama Panchayat. Memo to the whom? Grama Panchayat. Under the which provision? Either Tahsildar initiated the proceedings either under Land Encroachment Act or Land Telangana Assigned Lands Act or Grama Panchayat Act. Gram Panchayat Act, Tahsildar is not having any power. Exemption proceedings when arises. Yes, exemption proceeding. Now, according to the land belongs government only. From whom we Gram Panchayat. How? What is the source? How we are saying that this is a government land? Which record? Which record? One minute.
Report of the very same MRO
Yes.
Vindicate my stand. 196 by A.
Yes, your counter. Page number 109. One not name is no. No. Oh, one minute. Who is the original owner of the property? Government. There is no dispute. The total 196 consisting of 9 acre 28 guntas. 9 acre 28 guntas is originally private property. Out of 9 acre 28 guntas, 6 acre 28 guntas sold to the Grama Panchayat, local body. Now the remaining 3 acres, what happened?
That was subdivided 96 by A. 96
Yes.
96 by A consists.
Yes, there is. You are also admitting. Yes. Then what? 196 double A, where is that property?
They are the same. They are simply that they punch.
We are also relying upon the same. Yes.
Yeah.
Then who has to approach? Government is owner of the property in respect of 196 by A only. Now identification of the land is dispute. Yes. No. No. In the absence of any. No, who has to demarcate? Now suppose you are taking position from the Grama Panchayat. Now the Grama Panchayat, now we are taken position from the Grama Panchayat. Resume. Whether during the course of resumption, whether any Panchanama or any survey conducted. Where is it? That mere conducting Panchanama, taking position, that is not it, individual. Yes. Can the subdivision taken place? That's clear.
అంతే 75.
75.
ఇది ఏంటంటే 6 acres 28 guntas and 3 acres after the.
When the government resumed 2015.
2015, MRO indicates that 196 by A was occupied by so many people and constructed.
According to the report submitted by the Tehsildar on 15/9/1995 is a wrong report. No, 15/9/1995. The report submitted by the Tehsildar. Tehsildar to the District Collector Rangareddy, page number 45. Now that report is in favor of the petitioner.
We are not. I just vindicate my stand.
Report in respect of only page number 45. 45 to
59.
59. Now, what he says, 3 acres, 8 guntas pertaining to the Grama Panchayat land encroached by the encroachers pertaining to survey number 196 by A. Yes. No. Now, according to you, 3 acres, 8 guntas Grama Panchayat land, whatever the land which are resumed by the government, according to Tehsildar report 15/9/2015, occupied by the more than 66 encroachers.
Houses were constructed.
constructed, not in the survey number 196 by AA.
My counter. It is submitted as the data finding out the position of the set land in the market. There exists a water tank after the adding has been using in the set land.
Now, this is a very small dispute, whether identification of the land, whether the survey number 196 AA, the report, now we are saying that the encroachers are in possession of the property in survey number 196 by AA, according to you. Not maybe. Your assertion is contrary to the report submitted by the Tehsildar, 59/2015.
By virtue of that report, we obtained stay. That's the reason they want to go against our property.
Now, now the entire survey number 196 in your custody.
Different.
One way encroaches, one way bona fide purchases.
He also purchased from the builder. Builder must have problem. These gullible people purchased the property in order to give a quietus.
Oh, agriculture market will come to cattle shed. Good is cattle market. No, okay, not.
Any photo is
Yes, government paid. Which date convenient? Yes, what you are going to say now, the 3 acres of agriculture market committee, 3 acres?
8 guntas.
3 acres, 3 acres, 3 acres, 8 guntas in survey number? Yes. Now, according to you, the one minute. According to you, the whatever the land which was allotted to the agriculture market committee belongs to you.
Now, by virtue of the improved proceedings, because Hari, 196 by A, because 196 by
196 by
already in the court, they obtained stay.
Already in the custody of the under the position of the
Various encroaches of 55 houses were
property encroached by the agriculture market.
Now,
under the guise of
this. That's
yes. Now, how to dissolve?
The only thing is, now how going further.
What the senior wants to propose is to ultimately it can go into this aspect and declare.
And I am not on the point.
Yes.
May I request for both the parties, the Lordship may set aside these and direct the authorities concerned to conduct a survey in the presence of the petitioners as well as that will solve the issue.
Now, ultimately, they are bona fide purchasers. Now, the entire proceedings behind their back. Now, whether they are now, yes, but eyes on the date of this in a bifurcation, subdivision, which extent of the land falls in 196 by A and which extent of the land falls in 196 by AA? How to determine?
That Kasra indicates that 196.
Now the report says, Tehsildar report says 3 acres 8 guntas are in custody of the encroachers. Yes, yes. When the revenue GPs are going to take care this matter? Which entry model? 4 to 1 516. Yes. What?
Yes.
No, the 196 already protected.
Already protected by the court.
The encroachers protected. They are already. Yes.
Without going into all the what my ultimately this court can Only thing is,
This court is not having a hotel side jurisdiction
that's
to
a,
determine
what my,
declaring
if you,
marketing, advocacy, marketing committee's owner or the petitioner.
sir,
The allotment is, everything is subject to other.
subject to what my learned friend says, that's subject to your lordship, Millers. My only endeavor is to direct the, both the, in the presence of both the parties, let the survey and demarcate it and
after considering the objections,
yes, ma'am.
appropriate
Yes,
decision
ma'am.
till
That's
status.
yes, ma'am.
That is now without going to the.
Without going into the.
Now without going to disturb your position and their position. Demarcate, conduct inquiry, consider the objection and take appropriate decision considering.
If they succeed that the property really
yes.
in the 196.
Otherwise, they will claim against the who sold the property. They initiate the proceeding. Yes.
That will end the dispute.
Yes. Yes, heard Sri Chella Dhananjaya, learned senior.
And another connected to this by some. That's a way, other way plot owners. Correct.
Now you are
We
going
to give a quietest
you are going to accept that proposal. You are in the interest of the government, agriculture marketing committee, as well as the
petitioners.
Election duty. Now their instructions not required. They already file. You already file counter. Go through the counter. Report. Position already. That is says position is already there. Now the property. 16th or 17th, 18th, 3 days. 23rd.
Then the 29th minutes I will be out of station.
29th.
If my presence is not needed.
29th. Just 29th. Yes. Post on 29th. During the course of hearing, the London Council all the two connected matters also pertain to revenue department only. Yes, revenue same. Yes, during the course of hearing, the London Senior Council submits that in respect of the very same subject property, another two writ petitions, WP 997 of 2017. Right. The registry has to obtain necessary orders from the chief judge.
Revenue. Even revenue.
Now this court is not having revenue Grama Panchayat. Why these matters are listed? We will just only administrative side. That's right. Yes. Yes.
There also the
Yes. Whichever. Yes. Better. Now the government revenue role is very, very important. That's all. They resumed the land. Now they will take it. Suppose the Honorable Chief Justice allotted. Now we recorded, yes. We stated already, yes. Right.
May I please, Your Worship?
Yes. Yes.
This petition is filed against the action of the respondent number 3 to 7, my lord, for non-considering the representation of the petitioner, non-initiating to conduct the detailed inquiry on the illegal and fake Patadara passbooks of the respondent number 8 to 12, my lord, and non-initiating to cancel the Right Bandhu and Right Bima schemes which was issued by on behalf of
One
the
minute. Giving reports on hearing and senior.
Your Lordship,
Yes.
Originally the petitioner purchased the land from the respondent number 8, my lord.
Respondent number 8.
Yes, my lord. Then after he went to the USA for the job purpose, my lord. And mutation on the name of the petitioner, same is pending since long time due to some formalities and demanding of money, my lord. And meanwhile, the respondent number 8, by taking the advantage of his name in Dharni portal and his name in revenue records, he registered same subject land on the name of the respondent number 9 to 12, my lord, and made a double registration with it.
Yes.
And now they are on the basis of sale lead, they obtained the Patadar passbooks and they made an entry in the Dharni portal, my lord. And basing on that, they are getting the Right Bandhu and Right Bima schemes, my lord.
Yes.
And for that purpose, we also filed a criminal FIR also filed, my lord, for cheating. And also we made a representation before the district collector and Tahsildar also, my lord. But they are not taking any action against the same, my lord.
How now whether the Tahsildar and the criminal court is having a power to cancel the registered sale deed executed by the.
No, my lord. We are asking for the detailed inquiry regarding the issuance of illegal Patadar passbooks on the name of respondent number 9 to 12.
How we are going to say illegal Patadar passbooks?
Your lordship, same subject property, same survey numbers, they are registered double registration, my lord. Kindly see the EC, my lord. We have a EC.
1 minute. According to your pleadings.
Yes, my lord.
Petitioner is an owner of the property.
Yes, my lord.
He went to abroad.
Yes, my lord. He purchased in the year 2013.
No, he went to abroad. When he was in abroad, he executed the general power of attorney.
Yes.
In favor of 8th respondent.
No, my lord. 8th respondent is the original owner, my lord. Petitioner purchased the land from the.
No. Who executed the sale deeds in favor of the respondents 9 to 12?
8th respondent.
8th respondent. Who is the 8th respondent?
My vendor, my lord.
Your vendor?
Yes, my lord.
He executed the registered sale deed in your favor?
Yes. Initially on my favor, and after that, in my absent, he also taking advantage of the revenue entries. He also made a one registration.
He sold the property in favor of the unofficial respondent. He executed another sale deed.
He colluded with the revenue authorities and he made a registration, my lord, in favor of the unofficial respondent.
Yes. According to you, the sale transaction is the first transaction.
Yes, my lord.
Now the unofficial respondent 9 to 12.
All are colluded and all are actually planned to.
Where is your sale deed?
My lord, kindly see the page number 22, my lord.
22. This sale deed dated 9 December 2013.
Yes, my lord.
2013.
Yes, ma'am.
In respect of what is the extent of the land?
Your Lordship, kindly see the page number 26, my lord. There is a shoot schedule property.
1 minute. 26. Yes. 1 acre, 8 guntas.
In 162 by E by R. And other survey numbers also mentioned in second schedule, my lord.
Total extent of
Total
land?
extent of 4 acres 35 guntas, ma'am.
4 acre, 35 guntas.
Yes, ma'am. And in same survey numbers, he
Now the basing on the particular register sale deed, your names were not, your name not mutated in the revenue records.
yes, my lord. We applied for the petitioner applied for the mutation, my lord.
Yes, eighth respondent, when he sold the property to the unofficial respondent.
One is kindly see the page number 38, my lord. One sale deed is there.
Page number
38.
38. 38, yes.
Vaikunta Srinivas, my lord.
20 July 2016.
Yes, my lord.
Extent of land, total extent of land? Mittapalli Ramprasad, yes. Now, pursuant to the sale deed executed by the 8th respondent in favor of the unofficial respondent 9 to 12. Now they are in possession of the property.
No, my lord. They are just only the.
You are saying that they are receiving Raitu Bandhu also.
Yes.
Their names were entered in the Dharani.
Yes, my lord. On basis of illegal Patadar passbooks and.
How can you going to say illegal Patadar passbooks? Only pursuant to the registered sale deed executed by your vendor.
Your lordship, EC entries also made, my lord. Kindly see the page number 129.
Now, what you want in the writ petition?
My lord, I want to just cancel the illegal Patadar passbook and stop the Raitu Bandhu and Raitu Bima schemes which are original.
Patadar passbooks are issued pursuant to the which document? What is the basing on the which document the unofficial respondents are claiming their rights, position,
Sale
title, sale deed? Whether this court is having a power to declare the sale deed
But there is an involvement of revenue authorities, my lord. Without involving
whatever it
revenue,
may be, that is altogether different. Pursuant to the sale deed executed by the 8th respondent, unofficial respondent 9 to 12, their names were mutated in the revenue records, Patadar passbooks and title deeds were issued and also entered the names in the Dharani portal. Now, what is the law?
we are asking for the detailed inquiry, my lord. We are made a representation before.
Unless and until the sale deed executed by your vendor declared as a null and void, you are not entitled to seek any reliefs. That everything is in a consequential.
District collector is a concern.
Now, when you came to know about the alleged sale transaction, now by virtue of filing of the writ petition, the petitioner is foregoing his legitimate rights. Ultimately, you are not in position.
No, my lord. We are in possession, my lord. My father and my brother is looking forward for the agricultural activities. We also mentioned in our affidavit also, my lord.
Limitation starts from when? For recovery of position, declaration, declaring the particular sale deed as illegal and null and void, not required.
My lord, we once we get to know that there is a illegal fake Patadar passbooks are obtained by the respondents, we made a representation before the district collector, my lord, to inquire detailing.
The Tahsildar, RDO is not having any power to ignore the registered sale deed executed by the 8th respondent in favor of the unofficial respondent unless and until the sale deed declared by the competent civil court as illegal and null and void.
My lord, without knowledge of the Tahsildar, without knowledge of the
suppression. You want to pursue this petition? How long? Your limitation goes for filing civil suit.
My lord, without involvement.
Even suppose the criminal court is going to convict the unofficial respondent, whether you are going to get the property, criminal court is having a right or any jurisdiction.
And what,
Only ultimately if the court come to conclusion 420.
yes, my lord.
Only the criminal code, you punishment, imprisonment. You are interested to prosecute the criminal
No, my
conviction.
lord,
Not interested in property.
they are on the basis of the fake Patadar passbooks and all, they are interfering into the peaceful position of the
You're not,
petitioner, my lord.
whether
By
what do you
taking
want in
advantage
this
of the
petition?
documents, fake documents, they
Now,
are
what do you want in this petition? What is the relief sought by you?
might be disposed on by
No,
considering the
please
representation.
read your prayer in interlocutory application is very peculiar.
Yes, my lord.
IA 1 of 2022.
Direct the respondent not to alienate the land of the petitioner on
Direct respondents means whom? Unofficial respondent. Not to alienate the land of
no,
the
my lord.
petitioner. Whether this court is having a power to grant injunction against the unofficial respondent not to alienate the property in favor of the third parties in the writ jurisdiction. The relief which was sought by you is unknown to law.
We are asking interim relief, my lord, until and unless the detailed inquiry is conducted, the true facts may be revealed, my lords.
You're not very much interested to safeguard the rights of the petitioner. Please think over, discuss with your senior or any other senior.
We also filed proof of service, personal notice also served, my lord, even though they are not coming.
Even the personal notice is served if the unofficial respondent not entered appearance. Whether this court is having a jurisdiction to adjudicate the writ petition in this manner.
They are just asking for the consideration of representation to take to inquiry, detailed inquiry about
Whether your client going to achieve anything by virtue of passing that order. Or you are
basing on that order, we will file civil suit, my lord.
Civil suit for the purpose of filing civil suit, no judicial order, consideration of the representation.
No, my lord.
Mercy of this High Court or mercy of the revenue officials not required. That is a statutory right. That you're not understanding. Better to think your senior, this is very valuable properties, valuable rights. Suppose this court is going to highest court, suppose this court going to say anything, this is adverse to the your own client. Better just for your own benefit.
If the unofficial respondents are clear, then why can't they are appearing, my lord? We have served notices 2 times, my lord.
That they are cleverly watching the proceedings. Because if this court is going to add anything, they will take advantage in the civil proceedings. You are not understanding. Better think any from civil lawyer. Better take advice. Do justice to your own client.
My lord, my small submission is, kindly see the EC, my lord, after registration of, after
Yes.
my entries.
Better go discuss with any senior. Come, which order you want, this court is going to pass that order. If this court is going to allow your writ petition, you will not get anything. You will not gain anything by during the process. Now you are losing the entire limitation. Declaration, 3 years limitation goes while cancellation of the sale lease goes unless and until the particular document is declared and null and void, you are not entitled to recovery of position. Yes, better. Why? No, contempt. What is that is your own interest. Please, better think. Go through the provisions of this
Next week, my lord, my
statutory
senior will appear.
even senior appeal. That is you are the best counsel. Now, take advice, discuss with any senior civil side. Yes. What is your good name?
Suhas.
Suhas. Then yes.
Deep law.
Yes. ఇప్పుడు డేటా ఇప్పుడు ఇచ్చాను. ఎస్ ఎస్
Hari Prasad.
ఎస్ హరిప్రసాద్.
Lordship, I am appearing in this case, Lordship. Lordship,
Yes. Are you at Karimnagar?
Yes, sir. Yes, Lordship.
Oh, very good.
IA 1 of 2021 may be allowed, Lordship. Implement petition, Lordship. Earlier it is a Rekurti Gram Panchayat, Lordship. Later it was merged into Karimnagar Municipality, Lordship.
What is the issue in the writ petition?
Lordship, the issue is that, Lordship, the respondent number 6 and petitioner are the joint owners of the property in survey number 97, survey number 49, 96 and 97 plots, Lordship. They are the joint owners, Lordship. Without my knowledge, the R6 sold 150 square yards to one Bhadrama, Lordship. Without my knowledge. And the registrar issued a notice, Lordship. I gave reply, Lordship. While pendants of that matter, Lordship, the R6 with the help of R7 and R8 installed a deity of Shivalingam in my land.
మంచిదే కదా, దేవుని విగ్రహం పెడితే కూడా మీరు వద్దంటున్నారా?
But my land, Lordship, I am ready to give, Lordship, but there must be a document that is which has to be executed by me to the
Your
temple,
name
Lordship.
yes. What do you say? Please take the permission of the landowner. He is ready to donate the land for construction of the temple. Put his client name. That is, you file affidavit to that extent. You are ready to donate the land for construction of the temple.
Lordship, but
That is but arrange a second step. Whether you are willing to, your client willing to donate the land to the construction of the temple.
Lordship, I am ready, Lordship. Already temple was constructed and walls were erected and sanctorum also, everything is completed, Lordship.
Now, what more you want? Construction of the temple is everything is what follows now.
Now, Lordship, the municipality.
Now you are seeking direction. Declare the inaction of the respondent, passing orders for removal of deity. This is very more powerful. Now, is it permissible? Removal of removal of Lord Shiva. Only it happened. Now we are seeking relief. Removal of deity of Lord Shiva, Shivalingam. Whether any person, any officer is there to do. త్రేతాయుగంలో రావణంతో కాలేదు, ఇప్పుడు వీళ్ళతో అవుతుందా? రిమూవ్ ది లార్డ్ శివలింగం. ప్రసాద్ గారు,
sir, Lordship,
whether it's possible for the officers when it is not permissible, but not.
Lordship, as per Jivo 35, Lordship, they have to take permission from the Gram Panchayat, Lordship. That was not taken, Lordship. Moreover, the document has to be, the title of the land should be clear, Lordship, before obtaining the permission.
No. How
The
can
number filed by the respondent authorities clearly shows that, Lordship.
now you are at Karimnagar? Better to choose Karimnagar forum is better forum, better court. They will decide whether Chandra Raju is the owner of the property or whether any other person is owner of the property. Now the temple already constructed. Better think. This court is not having any power to issue mandamus, remove the Shivalinga from the land in survey number 96. Declare your petitioner is the owner of the property.
Lordship, implement may be allowed, Lordship.
No question of implement. Get to instruction from your client. Pursue the remedies. Better. Land Council Sri Hari Prasad, after arguing the matter, seeks withdrawal or granting liberty. Better.
Lordship, I am asking to implement the municipality. Lordship. That is the
No purpose would serve by implementing the municipality or commissioner of Gram.
I will get instructions, Lordship. I will get instructions. He is also an advocate, Lordship.
Yes, very better. Both Land Council Sri Hari Prasad, after arguing the matter, at length seeks seeks short adjournment for get instruction. At his request, post on 16th. Very same Rahul Bhaskar, your case comes on 16th.
No, Lordship. 2 weeks time may be granted.
Why 2 weeks? Your advocate, your petitioner also advocate is staying Karimnagar. Better.
Yes,
Today on, yes, inform. Better.
Okay.
Yes.
I will inform.
Yes.
Monday.
This is in a construction of Grama Panchayat building. Who is appearing? Sushman Reddy. Sushman Reddy.
My lord,
Yes.
my lord, lordship, kindly pose the matter next week. I'm handicapped, my lord. I don't have the bundle. Sorry, my
Now the
lord.
Grama Panchayat expressing urgency by virtue of the interim order granted by this court.
My lord,
Construction
then
of the Grama Panchayat building stall. Now the funds allotted by the government is going to be elapsed. Neither your benefit nor benefit of the Grama Panchayat.
Yes, my lord. Any date next week, lordship may kindly pose a matter. Lordship may kindly dispose. I'm handicapped. I carried wrong bundle, my lord.
Tuesday,
Yes, my lord.
immediately after Diwali.
Yes,
Yes,
my lord.
Land Council appearing on behalf of the petitioner seek short adjournment. Here is request post on 14th. Yes. Get. Yes. Yes.
Not made please, Your Lordship. The petitioner before Your Lordships, my lord, made an application for construction of a residential building. And my lord, the same was granted, my lord, which is at page 31 of the material papers. My lord, it was granted on 28/7/2018.
28/7/2018.
My lord, he immediately commenced the construction activity, my lord, due to paucity of funds. It was stopped thereafter, my lord, due to COVID pandemic. My lord, it was stopped for some period. But subsequently, my lord, he has commenced the construction activity, and when the construction activity was at the fag end, when the third and respondent, my lord, interfered with the construction activity, my lord, and they have demolished part of the walls. Therefore, my lord, the petitioner was constrained to approach this honorable court, saying, my lord, that the respondents are resorting to coercive steps without following due process of law. My lord, they have filed counter affidavit saying, my lord, your lordship would see the counter. My lord, along with the counter, they have filed some material papers saying, my lord, that they have issued notice, prior notice, which we have denied. My lord, your lordship would see at page 10 of the counter.
Yes.
This is the first notice, my lord, which they are referred to. It is informed that G. Anuradha, through this notice, under the limits of Gram Panchayat Revenue Insurance Group, you have constructed the constructed without obtaining Gram Panchayat permission. Why GOMS 111? In this area, any constructions are not constructed. If you construct any construction, we will take action against you as per Telangana so and so, brackets, farmhouse, compound wall, first notice. My lord, this is the first notice. Page 12, my lord, they say, my lord, in the counter they have referred to, these are the first notice. Page 12 is the second notice they have referred to. Page 14, my lord, is the third notice. And page 16 is the fourth notice, my lord, which they have referred to in the counter. Yes. In the counter, my lord, your lordship would see at para 6, my lord, counter page 4.
Yes.
Page 4, my lord. I refer to the notices. Respondent issued notice dated 17/3/21, directing the petitioner to stop the construction since there is no construction permission and the area is covered under GOMS and so. Despite receiving the notice, the petitioner did not stop the illegal construction. Thereby, this answering respondent issued another notice 31/3/2021, directing the petitioner to stop. Next parameter, it is submitted. Thereafter, the petitioner again continued the construction, and this answering respondent issued another notice dated 21/10/21 and subsequent notice dated 26/10/2021. But these four notices, my lord, which are at page 10 to 16, my lord, which I have referred, my lord, these are not served on the petition. My lord, we have specifically stated in the affidavit,
yes,
in the as well as the reply. Lord, your lordship would see the notices. They say that they have first notice they have served on the petitioner. There is nothing on record to suggest that these notices were served on the petitioner. Lord, your lordship would see the reply, my lord, submitted by us. Reply.
Now what happened?
Now, my lord, we have stopped construction. My lord, page 3, my lord, page para 4, my lord, your lordship, of the reply after.
Yes.
Para 4, my lord. It is submitted that the duration of permission obtained is for a period of 2 years, which ends by 27/7/2020.
Yes.
The said period ends with the COVID pandemic, and therefore construction activity could not be completed. It is submitted to the Honorable Supreme Court. In fact, extended limitation and other permissions granted by various authorities for a period of 2 years from 30/3/2020. The petitioner is also entitled to the benefit of the said judgment of the Honorable
Supreme Court. At any rate, the petitioner submitted application seeking extension of permission on 21/22 and the same is kept pending. Therefore, the submission in para number 4 and 5 are misconceived. Director of Marine Merit will have to reject it. In reply to the amendment in para number 6, it is submitted that the subject property does not fall under TO 111. As alleged, the petition specifically stated in para 6 of the affidavit filed in support of the petition that number of permissions were granted to the buildings in the adjacent areas, and the petitioner also filed photographs to substantiate the same. With this, we have stated in the writ affidavit, my lord, as well as in the reply affidavit. As stated above, the government itself issued pattas for construction of buildings, houses, where number of houses are constructed. From the above mentioned facts, it is evident that number of constructions came up in the subject area, as the same do not fall within the subject GO 111. At any rate, GO 111 has now been scrapped by the government, and the objection in that regard cannot now sustain. My lord, your lordship, in the petition, my lord, along with
What happened that public interest litigation filed by the some of the
pending, my lord,
pending,
still
challenging
pending.
the
Yes, yes.
withdrawal of the GOMS.
Withdrawn, my lord, it is withdrawn, my lord, through
Yes, sir.
GMS number 69.
Now the bill pending, still
Bill is pending. my lord.
Yes.
Now the restrictions are, my lord, diluted in DO 111. But my submission, my lord, page 42, your lordship would see number of construction, page 42, my lord, of the main petition. My lord, government itself constructed and number of construction within the, only the petitioner is being singled out. My lord, my one submission is, my lord, the notice is issued on two grounds, saying that there is no valid permission and that it is within the vicinity of 51. I have specifically denied that no such notice is issued before taking any coercive steps. But my only submission is, my lord, in view of the changed scenario, let them give fresh notice, my lord. I'll submit explanation.
Yes. Yes. What do you say? That is genuine. Now, till such time, the status quo granted by this court, we continue.
Your lordship may not stay.
Only consider.
Because
now the extent.
Completely, my lord, the building got damaged and no, I'm not asking any concession. Your lordship may say, let them give notice and let them consider. That's all, my lord.
Now, till such time, till such time, consideration of the exercise, complete the entire process. Now, if you
Your lordship may leave it there, my lord, because lot of my lord.
Now, this till such time, not to take any coercive steps by the respondent. The status quo applies to both. That is no. That is now we are waiting.
Not to take any course. If there any
similarly that applies.
Because my lord, now simple plastering also they are coming and objecting. My lord, there are a lot of difficulties. My lord, your lordship may say let them not.
How much time required to complete the entire process? Now this election. 8 weeks. Now the status quo operating. Now this
difficulty, my lord. No, small work. No. They have demolished, my lord. Simple, small.
Restoration. Status quo obtaining today with regard to subject building properties.
That's the reason I moved the petition, my lord. Now a lot of difficulty.
Petition. The order which was granted.
Lordship may not even say coercive steps, my lord. Your lordship may leave it there, my lord.
January 2022.
It would suffice, my lord. Your lordship may leave it there. Not even coercive steps, your lordship may say. Only say let them issue notice because lordship knows, my lord. My lord, your lordship knows, my lord. There number of construction besides the building of the petitioner, number of construction. Only petitioner is being singled out.
Not to take those steps. Suppose the respondents takes any steps.
Let them take if we construct.
Now this the order is continuing since January 2022. Now 2024, just 2 years, below 2 years. But yes.
No, but because my lord, we know the mindset of these people. That's the reason, my lord.
For your own interest, that is
that's the reason I am also saying, my lord, your lordship may not even say not to take any course. Your lordship may, my lord, just direct them to issue notice, my lord, will submit reply. I am not even asking for any concession of taking any coercive steps. Your lordship may leave it there, my lord. Because my lord, your lordship knows the difficulty.
Yes. WP number. petition is disposed of according. Yes. 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 What Devdas? See, where are you? Since long time. Now we are leaving entire thing to Srinivas. You are at Amaravati.
Yeah.
Yes. Left side one, right side one, colleagues. Yes.
Let's.
Yes. What is the issue?
Issue is, my lord, the panchayat.
Who is RA2? Who is RA9? Why you are made him implemented as a
My lord, this site belongs to panchayat only for purpose of constructing a community hall.
No.
That is
Now
the
the
government.
Sarpanch constructing the residential building.
Yes, she was allotted, the Sarpanch is allotted to his own relative and granted a house site. That is the inquiry report is, that's
One
the,
minute. Who is the panchayat? You are representing Gram Panchayat. Yes. What is going on? What instructions?
Lordship, Tahsildar report is there, page 17.
You are appearing on behalf of the. We'll give one opportunity. Yes. Why 2 weeks? You are saying that only signature is required. No. Even before verification of the document, you prepare the counter. No, that's no. Now suppose whether you are going to give undertaking in the event, suppose the restriction is allowed, you are not going to claim any equities. Already I been 1 minute.
It's not MRO.
Price bandhu, how the government, huh? That is altogether different. No. Whether the construction made in the survey number 215 by A, which is a public property, whether this property belongs to Sarpanch.
Yes.
Yes, wills. File, yes.
He is a lot of litigant. He filed writ petition.
Yes, Nambi Krishna, Lanu Council, appearing on behalf of. First you are making construction. Yes. 18. First you. Yes. Chaudhary garu, your matter, someone made request to adjournment on behalf of you only. Morning 10:30.
Milord, I am petitioner.
Yes. At your instance, someone made a request morning 10:30.
At the instance of, it may be respondent, Milord.
R8. No, they says, I am representing BHR Chaudhary. We request some time. In morning 10:30, they made a request. Application. Any urgency? Matter posted to 23rd already. 23 level. They are not informed.
They did not inform me. They have taken time several times. It is pending since last 1.5 years.
Sorry. Now what is going on? File వెళ్ళిపోయిందా? Morning 10:30 they made 2311. ఈ నంబర్ రాసి పెట్టుకోండి. Next time. Yes, 20. Yes, we will. Now the first morning 10:30 will. Now morning we trusted the councils. That's how can we? Yes. Yes. Next. Which 83 is made up.
80.
You are representing
84.
84. 83. Who is? What is the issue? Yes. Then the matter is one minute. When the matter is taken up for hearing on 7/11/20. Yes. Yes, please. Pilwan.
My lord, I'm representing the council for respondent 6, my lord.
Yes.
In this matter, my lord, we have filed a counter. Counter has been.
You are representing unofficial respondent.
No, no. Respondent number 6.
6.
4.
Yes. What do you want? They are making illegal construction. They are having sanction approved plan. Oh, you are representing Chitralekha. Yes. When the matter is taken up for reading on 2/11/20. Yes. Yes. Yes, Sunil. Yes. No representation on behalf of the.
The petition is filed challenging the act of the respondents. Like you see, the petitioner purchased the land and they are having the Patadar passbooks without initiating any land acquisition proceeding for laying a road.
Now, vacation petition pending?
Yes, vacation petition pending. I also filed a reply.
Who is
Your Lordship, they admitted that, Your Lordship, they are without initiating any proceeding. They are laying the road. And the only condition is that we are agreed for that. We are not agreed at all.
Who is appearing for respondent? We'll give one option. Now, 430 vacation petition.
Yeah.
At the request of the land assistant government feeder, post on 1611. Yes, the page work will one. Several advocates are with. Two writ petitioner. No, one more writ petition 94 also connected.
No,
yesterday,
it is not connected.
Yesterday, someone says 94 also connected.
Let me see.
Not connected.
Different writ petition of 2020 was listed with regard to the same parties and same subject, and they in that matter also they have constructed illegally. As such, I have requested for the tagging of the same. However, the 94 matter is a different matter.
Now, these two matters.
These two matters were listed on today. There is one more matter also, 8263 of 2020.
8263
of 2020.
82
WP 8263 of 2020.
2020?
2020.
Yes. Yes. What do you want? No, that matter also required to hear.
These matters
Filed by in respect of very same property.
In respect of very same property and very same
to avoid conflicting orders. That is the interest of the. Now he says subject property.
May I say one thing, right? In that also, I am the petitioner and he is the unofficial respondent.
Get one more case.
No, same property, same illegal construction. However, he has completed that construction.
1 minute. 87, 88. When the matter is taken up for hearing, Sri. You are having urgency? No. Yes, sir. Which date you want? 18, 17, 17, 11, 20, 23. 8263 of 2020 pertain to the Panchayat.
Same subject. Yes. All parties are same.
Yes.
Yes.
Is Ishwar required hearing?
Yes, the construction is going on now. The
construction going on.
On the petitioner's property, Milord.
Who is making construction?
The Gram Panchayat, Milord.
Gram Panchayat making construction?
Yes, Milord. They're building, Milord.
Gram Panchayat building, Gram Panchayat making construction.
Yes.
Very now clear. You are having instructions? Counter is, there's a counter, this court is going to grant counter. In the meantime, If you are going to, your Panchayat Secretary is going to give undertaking that in the event the petitioner is succeeded in the petition, the Gram Panchayat will not claim any equities, get instructions. We'll take up.
It is only for instructions, my lord, urgent from 20 to 9.
Are you received instructions? Get instructions. Yes. Post on 16/11/2023. Yes. By that time you get instruction. Yes. You could get independent.
91.
May I please, Lordship, the matter is coming up for counter, Lordship. Unofficial respondent filed the wakalat.
There is an entry order in your favor.
Yes, Lordship.
That's why you are saying counter. Counter already filed, Kishore Rao.
Unofficial respondents are
Unofficial
sorry, Lordship.
Notice
Official
service.
respondents are filed, Lordship.
Proof of service not filed.
The already wakalat is filed by the respondents. Lordship.
Who is Bhagavant Reddy? Yes. Post on at request of the Land Council for the petitioner. Post on 20/11/2023. Yes.
Order may be extended, Lordship. It's a conditional order, Lordship.
What is the condition?
Objections of the petitioner can be considered.
This is an unlimited order.
Yes, Lordship.
Unlimited, no question of extension. Extension not required.
Much obliged.
Yes. Anyone there? Yes. Post on 16/11. Yes. Please, anyone having both sides, suppose this is not proper to hear after 4:30. Your case actually urgent to today only?
Today, at 107.
Tender matter?
Yes, my lord. My only anxiety before your lordship says that the season is going to
1 minute. Item number?
Item number 107, my lord.
107. Tender.
In fact, in the similar circumstances, the Lordship Justice Rajshekar Reddy was pleased to
Court officer 107 will take up on 16th. Court officer 107 tender matter. కొంచెం high up the list లో వేయండి.
motion list.
Motion list లో రాదు కానీ high up the list. We will see. Just we will instruction. Yes, one answer.
103, Lord, I am presenting case.
Huh?
I am presenting case. Sunil.
Item number?
103, Lord, I may be permitted to withdraw.
How the review petition is maintainable by changing of the council.
In fact, Lord, the order copy was not served on.
This court is want to hear the review petition, scope of review, order 47, rule 1. This now this court granted liberty, madam. Yesterday, when this court is going to go through the papers, you file a review petition. What is the review? Yes. Yes, madam, 103. IA 1 of 2023. When the matter is in WP 22025 of 2017, when this application is taken, why warning passover adjournment? Yes. Remain.
Item 93, my lord. There is a illegal construction going on by the unofficial respondent without taking any permission, my lord.
93, huh? In this, I am appearing on the respondent.
What you want?
I am 1 week.
1 week. Item 93. Now the land council is entered appearance seeking time for filing counter only 1 week. If they are going to make construction without any permission, that is their own risk. Why you are worried? They are spending their own amount. Suppose the court come to conclusion the permission not granted, Gram Panchayat says no permission, this court will issue necessary direction for removal. But what you want, removal. Is item 93, at the request of the Land Council, appearing on behalf of the
Respondent, Ramu Sharma Sharma.
We filed photographs, my lord. Presently, the construction is like.
nothing will happen. Illegal construction, they want to make illegal construction. What purpose, what you are going to gain by starting the now the workers.
My lord, they are constructing.
Right. Withdraw, but some committee. Withdraw చేసుకుంటే ఇంకేముంటుంది డిస్మిస్ లేదు withdraw. మెయిన్ రిక్వెస్ట్ ఆల్రెడీ డిస్పోజ్ ఆఫ్ అయిపోయింది అయిపోయిన దాంట్లో రివ్యూ వేశారు వాళ్ళు.